Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5289, Coalition for Humane Immigration Rights et al. Versus Kristi Noem in her official capacity as Secretary of Homeland Security et al. Appellants. Mr. Becker for the appellants and Ms. Sung for the appellees.
Good morning, counsel. Mr. Becker, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. Tyler Becker from the Department of Justice on behalf of appellants. I'd like to reserve 2 minutes for rebuttal. The district court below entered a universal 705 stay against 3 DHS documents that plaintiffs contend authorize expedited removal for aliens whose parole has been revoked. Yet plaintiffs lack standing to seek a 705 stay because their 705 motion did not challenge regulations that allow the very same conduct they alleged is harming their members, namely the application of expedited removal to former parolees. Plaintiff's 705 motion thus failed to demonstrate that a 705 stay was likely to redress their alleged injury under Lujan. Even if plaintiffs had standing to bring their 705 motion, it would fail on the merits. 2 provisions of the 1996 IRA permit expedited removal as to parolees whose parole has been terminated. First, former parolees are subject to expedited removal under what is commonly known as the arriving alien provision, 8 U.S.C. 1225 B1AI, because former parolees remain arriving aliens once their parole ends or is revoked. That accords with long-standing Supreme Court precedent on the entry fiction, where aliens paroled into the country are viewed as remaining at the border for due process purposes because parole is not an admission to the United States. And it accords with the parole statute, which makes clear that parole shall not be regarded as an admission, and when the purposes of such parole have been served, the alien shall continue to be dealt with in the same manner as that of any other applicant for admission.
Before we go too far down the road on that, can I just take you back to your threshold argument?
Yes, Your Honor.
Redressibility. So one feature of the redressibility argument that I'm not quite getting my mind around here is that typically in a case, standing and redressibility turn on the ultimate relief sought. And here we have an interim stay. So it sort of functions kind of like a preliminary injunction. It's to keep this in place while litigation is underway. And are there cases that say that a court is supposed to independently address redressibility/standing as to the interim relief? Because I know there's cases that say that standing has to be shown as to each type of relief sought. That principle is well established, but usually that has to do with the type of relief that's sought at the end of the day. So if a plaintiff is seeking both injunctive relief and damages, then the plaintiff has to show standing as to each. I guess what's odd about this case, and I don't know that there's another case like it, and I didn't see one cited in the briefs, is that here, there's no doubt that at least I don't think there's any doubt for our purposes that there would be standing and redressibility at the end of the day, because in the complaint, the regulation that you're relying on for redressibility challenge is being challenged. It's just that there's not a request for an interim stay of that regulation. And so what your argument basically says, and I think I'm not sure this is right, it may be, is that we treat that request for interim relief as if it were its own case or controversy for Article 3 purposes, as to which an independent standing/redressibility analysis applies as to that. Do you understand what I'm saying?
Yes, Your Honor, I understand what you're saying, and I think the government has looked for cases on this, and we're relying on the cases that say you have to have standing for each form of relief sought. And here there was a 705 stay entered, and for whatever reason, the plaintiffs chose not to challenge in district court, and even admitted in district court that the DHS could still use the arriving alien regulations to apply expedited removal to these same parolees. And this is, again, I think, an unusual case, and I think that's where we're relying on. I don't have another case on that.
And then is there something in first principles or something that tells me, because you've got an argument that says even if there is redressibility, or as I'm hypothesizing, we may not even look to redressibility independently for the interim stay as opposed to relief at the end of the day. There's still a question at the back end as to whether there can be irreparable injury for interim stay purposes when there's, under your argument, an independent regulatory basis for the same actions.
Yes, Your Honor, I think that's right. And the government would be fine with the court going down that route as well. I mean, I don't think plaintiffs can show that they had that they were irreparably injured if DHS can still apply the same, can apply regulations that they didn't challenge in their statement.
So here's my question about that then. Under your view, it's you look at it, it's happening either at the front end or at the back end. Either way, the existence of the regulation, the underlying regulation, and the absence of a request on an interim basis for a stay of that regulation means that the stay can't be affirmed. And my question about that is, if there's a practical difference between the extent to which expedited removal is being pursued based on the regulation alone or based on the regulation plus the directives that are being challenged and that have been stayed, then would that, under your view, mean that you get past the redressibility or back-end irreparable injury parts because there would be a difference? The directors are doing some work, even if the same actions could be taken under the regulation. They're just not. The directives are doing some work because they're acting as an instruction to officers to act in a particular way. And so they're in fact helping the plaintiffs in some measure. That's not to the exclusion of any arguments you may have on the merits, but just for these purposes on the effect of the lack of an argument that the regulation should be stayed on an interim basis. Would that kind of delta matter?
Your Honor, here, I think the question under Lujan is these plaintiffs sought a prospective stay, something that was going to prevent in the future the alleged harm, which was expedited removal to former parolees. And it's entirely speculative what sort of harm that is actually, what sort of harm that's actually going to have by not actually staying the regulations. I mean, it may be that DHS would apply expedited removal less. It could be that they would apply it the same. There's just no evidence in the record as to what DHS would do in the future if the stay was reversed, for example.
And what's been the experience?
Your Honor, DHS is continuing to apply the expedited removal to former parolees with this using the regulations instead. It has received some pushback from certain district courts. On our reply brief at page 7, note 2, we list some cases where district courts have ruled against DHS on this ground. And right now, DHS is only able to use the arriving alien regulations to do this because the designation, functionally the designation provision and the expanded designation that occurred at the beginning of the administration has been stayed with respect to parolees. So we can essentially only use the arriving alien provision, and a lot of district courts are just following what this district court did here in DDC.
But when you say you can only use the arriving alien regular, I thought the way that your arguments are nested, the arriving alien authority gives you everything you need. Why does the designation authority even matter if you have the arriving alien authority?
That's correct, Your Honor. It matters to the extent that we're not even able to, as to these particular aliens, we're not even able to argue that they're subject to the designation provision at all when we think they are under the language of that provision because they have not been paroled.
But does that?
So are you saying that these district courts in footnote 2 have disagreed with you about the arriving provision? And you think you might be able to win with them if you could argue the designation provision?
Your Honor, I think that's one thing that we just aren't even able to use this designation authority.
You're quite the optimist. They've ruled against you on what is probably your best argument. So it seems maybe optimistic to think they would rule for you on your second best argument.
Yes, Your Honor. I think that the issue here is that the other issue I would say, and that goes to what I think gets at maybe some of the government's irreparable harm, which I think may relate to these standing questions as well, is that right now in the district court, we're technically under a stay order, and the stay order is a little unclear whether it even reaches the arriving alien regulations. It purports to hold the regulations ultra vires, so it's technically an advisory opinion because the plaintiffs didn't challenge the regulations here. And now the government, I think.
Surely it's the case that it did not stay, vacate, enjoin officials who are applying the 1997 regulation, because if it did, then you would be committing actions worthy of contempt every time that you apply that.
Yes, Your Honor, but as I think you recognize, Your Honor recognized in the concurrence when denying the government stay application in this case, the government, it has been, since having to use the arriving alien regulations, had to make a decision about whether to actually even use these, given the district court's opinion.
You've made the correct decision based on the best reading of the injunction. And then going back to some of the earlier questions, I'm curious too, there was, I guess, a certain amount of applying expedited removal to parolees before the, probably even before the March guidance, before the March document. There's probably some amount of it before, and this is briefed, I'm not just like pulling this from the news, but before the directive went out to hit a 3,000 person a day quota. There was probably some amount going on after the district court's stay in this case, and probably some amount going on still today. And I am curious, like, roughly what are the numbers there? Because I'm curious whether the stay has slowed down considerably the pace that expedited removal was before the stay being applied to parolees.
Well, Your Honor, I don't have any particular numbers to offer you on this point, and I will say one of the reasons I think that's important is here the question is what would happen if the district court stay was actually reversed. And I think that what plaintiffs are saying is that they think that some of their injury actually is being redressed by the stay and by having the stay in place. And we just don't think that's the case, given that in the future plaintiffs have no evidence as to what the Department of Homeland Security would do if the stay was reversed. If we had two authorities to rely upon.
But if you were doing this to 1,000 people a day before the district court stay, and then that dropped to 5 people a day for the past months since the district court's stay, that would be some reason to think that a stay can redress the injury. But on the other hand, if you were doing 1,000 a day before the stay and you continue to do 1,000 a stay after the day, that would be some strong evidence, I think, for you that this stay is not checking the redressibility box that standing requires.
Your Honor, I think that it would be proper to look at that, but I think it's also important to take a look at what standing under Lujan actually requires. The plaintiffs need to show that their injury would likely be redressed. And maybe there's some evidence, and whether there's some evidence or not, as to if there was less expedited removal under the arriving alien regulations, it does suggest that there's no evidence in the record as to what DHS would do in the case that there was no stay.
I get that, but do you have an answer for what is the evidence about what has been happening during the stay compared to the week before the stay?
I do not, Your Honor. And I'll note that I think some of the plaintiffs' claims about arrest quotas and the like, this has to do with other things that have nothing to do with the stay or with expedited removal for parolees at all. So I'm not really sure that specific numbers would actually help in this regard. It would be entirely speculative. What
if the plaintiffs and I know your position is that it's the plaintiff's burden. But I'm just hypothesizing. Suppose the plaintiffs introduced evidence or an affidavit or something that said the pace of expedited removals has slowed considerably since the stay. Then at that point, would you say that your redressibility argument and your irreparable injury argument on this score at the back end don't work because the pace has considerably slowed since the stay?
Well, Your Honor, I think
I
think the issue here is that where we're looking at standing is technically from looking at when the complaint was filed or in this case, when the stay was filed. So I'm not sure that evidence, the government is under a court order to not apply expedited removal, and that actually says the arriving alien regulations are ultra vires, that would be enough evidence to suggest that plaintiffs actually have standing, because then it would be that plaintiffs would be able to
So then does that mean that no matter what, that there's no way in a case like this in which, I guess the plaintiffs could forecast before the fact, before the stay was entered, they could forecast that the pace of expedited removal would go down significantly if the requested stay were entered. But is that what you're saying had to have been, suppose that had been done?
Yeah, I think that would be a different situation. I think here we have plaintiffs admitting that you could just apply the same regulation.
But it's different to say that you can apply it and then to say how often it's applied. I mean, I think nobody disagrees. I mean, we can ask the plaintiff. I don't think anybody disagrees. It sounds like that the regulation can be applied and it would result in some expedited removals. I think the case, and it has. Apparently, you've represented that it has, and I haven't seen a dispute about that. But I think the question would be, is there a reason to think that it's just not happening as often? For example, if you have a directive that just tells officers, you have to do this, and then they're under an order from a supervisor or a directive to do it, whereas if that directive is no longer in place, then maybe they just don't have the same hydraulic pressure and institutional dynamic that brings this about.
Well, Your Honor, that's where I go to some of these, and some of these are in a different context, but I think the best case on this is Doc Society from this court, where there was a situation where visa officers or people that were investigating visa applications, there was a mandatory policy that the State Department created, and in 2019, there were regulations that allowed visa officials to consider in individual interviews whether those applicants' social media handles and would ask for them. But the mandatory policy, plaintiffs were alleging, actually made them go and reduce their speech as a result.
But I think the difference there is, and you're right to point to that case, because there's the mandatory, and then the idea that the panel on which the panel rested its decision is that there's still discretionary authority, and as long as there's still discretionary authority, then the plaintiffs still have an issue, and so there wasn't anything that the plaintiffs had submitted explaining why the remaining existence of the discretionary authority wouldn't have had the same effect. But I think the difference is that in that case, the injury that was being claimed is that, look, as long as there's any authority at all, we're not going to try for this because we're worried about our social media stuff being laid bare. And so it didn't matter if it was mandatory or discretionary, because the existence of it in any measure, whether discretionary or mandatory, would have discouraged the plaintiffs from doing the thing that was at issue. So it seems to me that it could be a little different here, because if here the injury is the actual prospect of expedited removal, and there's a practical difference between that likelihood when their directives are in effect and when they're not, notwithstanding the existence of the underlying regulatory authority, then it seems like that's a delta. Now, I mean, I understand your point that that's something that needed to have been done, and you would say it needed to have been done before the fact, and it just wasn't. But the prospect of that delta would be a reason that your redressibility/irreparable injury argument can't work.
Your Honor, then I'd probably go to I'd probably add just to that, that some of I think this is, they're in a slightly different context, and there aren't many cases in this, even like this, frankly. So the government is extrapolating from some of those. They're the cases that I think plaintiffs criticize the government for as being involving third parties, that actions of third parties would need to occur in order to determine whether there was actually redressibility. And I think that those cases are really helpful in this context, because they get at that there's just really no way to know exactly what DHS would do absent the stay. So for example, in National Wrestling Coaches Association, there was plaintiffs didn't challenge a regulation that essentially allowed the same conduct that later guidance and policy interpretations allowed, and while that depended on what schools would actually do with wrestling programs, it related to gender in Title IX. It didn't actually. It did, as a result of not challenging the regulations, it was just entirely speculative what the schools would do, and whether changing the interpretations or vacating these documents that are there would actually redress the plaintiff's injury, which was losing these high school wrestling.
So you're taking from those cases a kind of speculation rationale that says that unless there's some concrete indication that there would be a differential, it becomes speculative. The third-party cases indicate that, even if this is not a third-party case. Yes,
Your Honor. We can see this is not a third-party case. It's just that we just don't think there's a lot of other cases like this, and we're extrapolating from those.
Can I just ask one more question, just to go back to something you talked about earlier, which I'm not quite understanding, which is, you've made the representation in your briefing that there are expedited removals going on right now under the arriving in regulation.
That's correct, Your Honor.
Right.
Yes.
But then then you've made the representation that it's unclear whether the district court's stay has an effect on your ability to use that regulation.
Your Honor, the district court stay here does say that the regulation is ultra vires. Now, the government has relied on Halan versus Brackeen, which is a Supreme Court decision that says that redressibility depends on not on the opinion, what's in the opinion, but on the actual relief. And the relief did not vacate that regulation. Now, the district court stay, we do not believe actually vacates the regulation. It's from 1997. We don't think even that there would be we think there would be a jurisdictional time bar to even challenging it in this type of proceeding. But ultimately, the district court did purport to say that the regulation was ultra vires, and that
Right. So what I'm not understanding is, I think I understand everything you've said, except what I don't get is, if you've reached the conclusion, at least in some instances, that notwithstanding the district court's opinion and its language about the regulation being ultra vires, which you think its only language actually doesn't stop you. And in fact, the government has used the regulation to effect expedited removal as to parolees. Then why is that just not the government's practice writ large? Why would there be any concern about the district court's language if in fact the government is using the regulation in some instances? Why doesn't the government just think, all right, well, we can use the regulation in any instance?
Well, Your Honor, the district court did purport to rule that this regulation was ultra vires and that it didn't apply to these parolees that are here. Obviously, that could lead to, the government was obviously worried, although it hasn't happened, lead to contempt proceedings or other things, because the district court's opinion does include that language.
But are all the ones where the regulation has been used, did they predate the district court stay? Maybe
They did not, no.
Right, so that's what I'm not getting. If there are, I think I'm just missing something basic, and you can just tell me what I'm missing, that if since the stay, the government has relied on the regulation to effect expedited removal of parolees, then the government has clearly reached the conclusion that the language in the stay opinion doesn't foreclose that, and I understand that. If that's true, then I guess I'm just not understanding why the stay would have any effect on the government, and the opinion accompanying the stay would have any effect on the government's use of the regulation to effect expedited removal.
Well, Your Honor, I think the reason that it is having an effect on the government is mostly from the fact that district courts are using the district court's opinion and saying that the district court hears opinion and saying that that opinion applies to in the EV case, I think that we cite in reply brief note 7, the plaintiffs there are challenging the government and saying that the government violated the stay in that case, in this case, and that's happening throughout the country.
If so, that means it's just having the same effect as if the district court judge had written a law review article.
That's correct. So, I mean, we think this is ultimately an advisory opinion, and that's one of the dangerous things, and why we think you actually have to.
Why do you have standing to appeal?
Your Honor, I think that I definitely thought through this question, given the Make the Road panel's Carson factors, which I think this court has said apply here. And I think that it has to do with the fact, with two reasons. First of all, that district courts around the country are considering, and there are claims against the government, if the government is violating this stay and can't apply expedited removal under the arriving alien regulations. That would give you standing to appeal a law review article, so that can't be right. And secondly, the government is subject to potential contempt proceedings in district court as a result of the stay.
I mean, the government seems to be making a per se argument that all 705 stays are immediately appealable. But that's not what we said in, I mean, is that argument open to us after the Make the Road stay decision, which applied the Carson factors?
Well, Your Honor, I think the Make the Road stay decision applied the Carson factors. I don't think that the stay decision is a published binding decision on the court. However, we do think that we meet it here, given the two things that I just mentioned.
What is the best argument that all 705 stays are immediately appealable?
Well, Your Honor, any 705
cases saying that, or what's your best textual argument?
Well, Your Honor, the 705 stay is very similar to a preliminary injunction. It's because of you have to find irreparable harm, you have to find likelihood of success, and it would be passing strange if you could not appeal something that is functionally an injunction that is preventing the government from or vacating certain documents, not vacating, staying certain documents and not allowing them to have effect.
But as to that, is there any difference at that level between what you just said and what the Make the Road panel, the state panel decided? Because I think the same argument was before the Make the Road panel and it didn't find that persuasive, right?
I think the Make the Road panel focused on what harm there was potentially to the government, and it assumed that if the government was successful on the merits, that the government would have.
Well, I asked this question because I think here it is harder perhaps for the government to meet the Carson factors. So perhaps you can speak to why you meet the Carson factors in this case, where you're continuing to enforce the arriving in regulation even after the stay.
Yes, Your Honor. So I think that the Carson factors, under the Carson factors, there has to be there's a practical effects test, and it allows that or any sort of thing that's not that's like under 1291, only if it might have a serious, perhaps irreparable consequence and can be effectively challenged only after immediate appeal.
So
now
why
here,
does the government meet that?
Here, assuming the government prevails on the merits, the government has been subjected to a court order purporting to bar nationwide the use of expedited removal to parolees, including alleging or finding that the expedited that the arriving alien regulations are ultra vires, when the district court did not even have jurisdiction to do so. So it entered an advisory opinion, and at the end of the
And the government is essentially saying it was an advisory opinion, so we're continuing to do expedited removals. So what's the serious harm under the Carson factors?
Well, Your Honor,
the government's own, representation that it's continuing to effectuate this policy.
Well, Your Honor, I think that's a good question, but I think here the problem is that we still have these other district courts that are treating this order like a binding or nationwide injunction against applying expedited removal using the arriving alien regulations and using these documents.
So the government's position is we have appellate jurisdiction here because district courts elsewhere are misreading our district court's stay order?
Your Honor, I think
is that your best argument for serious harm?
I think that our best argument is that currently in district court we are subject to a stay of these documents. We are not allowed to rely on those documents. We cannot rely on the designation provision at all because we can't rely on the expanded designation that occurred earlier in the administration. And as a result, we're hampered in what sources of authority we can rely on. And obviously, if a district court if we only apply the arriving alien regulations to apply expedited removal to an alien, and we're not allowed to end up not being allowed to do that, we haven't been able to apply the designation provision.
Can I just ask on that, just to reconfirm, and let's cut you off. But it's adjacent to what Judge Rao was just asking about. On the designation one, I just want to ask it again. Am I right that the designation one doesn't matter if you've got authority under the arriving in regulation?
As to these particular plaintiffs, that is true. These are plaintiffs have only in their complaint brought a complaint on behalf of parolees, right, who were granted parole at a port of entry, as opposed to somebody who was, for example, entered illegally and then was granted parole. So for purposes of this
case, the hypothesized inability to use the designation authority just doesn't matter if you have authority under the arriving in regulation.
Well, and the arriving alien regulation also allows the government to use it beyond the 2-year continuous presence period.
That's why it's the big circle, and the designation one is within the big circle.
That's correct, Your Honor. And the issue here, I think, is that we're just not able to rely on the designation provision at all. But again, like we could rely on both authorities. And I think plaintiffs make some APA arguments about this, about how it's unclear, what authority we're relying under and the like. But ultimately, we were able to rely on both authorities. And to the extent the government was self-limiting itself to only applying it for the past 2 years, obviously it has two sources of authority that it thinks are proper there, whereas it doesn't otherwise.
Okay.
Just out of curiosity, what if you copy and pasted the 3 guidance documents, the 3 challenge documents, and, sent them out tomorrow?
The same documents have been stayed by the district court, so I assume there would probably be proceedings about whether we were complying with the stay order. But again, this gets to whether guidance.
It's not an injunction. It's a stay of the previous action. So I don't think a stay or even a vacatur of something in the past would stop you from doing it today.
Well, Your Honor, this gets a little bit more complicated here because part of the documents that are being challenged here are also at issue in the Make the Road case. The issue is that even if we would have to do basically an entire redesignation, we would have to expand designation again to being up to the 2-year statutory maximum mark.
Think about standing, both the standing of the plaintiffs in the district court and your standing to appeal. So for the purposes of this question, just pretend like the Make the Road case doesn't exist, which, in any event, what could you do what I'm hypothesizing? Could you just copy and paste these 3 documents, send them out? Perhaps the district court would stay there the next day. You copy and paste, send them out the next day, on and again and again and again.
Your Honor, the documents here, yes, I suppose you could do that, yes.
Okay, I think that again makes it even harder to kind of grasp what your standing on appeal is, but I'll let that go.
Do we really even need guidance documents to do what the guidance documents do?
Well, Your Honor, I think that's the government's
It's like enforcement discretion. So enforcement discretion can be, you don't have to write down how enforcement discretion is going to be applied.
Yes, Your Honor, I think that's right. And that's, I think, one of the problems in this case is that the plaintiffs challenged enforcement documents. One of them is an email with the one that actually applies using the arriving alien authority is actually just an email to staff members. And
isn't that your best argument about redressibility?
The document
are basically enforcement discretion documents.
Yes, Your Honor. I think that actually is a good argument for as to why there's no redressibility here, because ultimately all you can do is all the plaintiffs have done is challenge these enforcement discretion documents. There's old regulations from 1997 that they may not even be able to challenge in this type of proceeding here, and there may be no sort of because there's DHS can just choose to enforce those documents as it choose to enforce the regulations. Whether it was doing so in the past or now doesn't really matter. If they can choose to do so, that I think is the reason that there's no redressability here.
You focused on all these other third-party cases and all these other things, but I was wondering.
Yeah, Your Honor, I think that the reason for that is because this is a very odd situation where the plaintiffs below admitted that DHS could just use the same regulations, and the district court specifically considered our redressability arguments below and found against the government and said that there was redressability because some of their harm would be ameliorated by a stay, although we just never understood what exactly that harm was that could be redressed, or that part of their harm.
I have some merits questions, but I don't want to change the topic if you have more understanding. So I'm a little unsure what your position is for parolee who has been paroled his entire time and has been paroled for, let's say, 3 years. I understand that if that person is still on parole, then expedited removal is okay. But let's say that parole is lifted today. Can that person be put in expedited removal tomorrow?
Your Honor, under the arriving alien regulations, yes.
Okay. And so, I mean, that just does, and then let's say that they were paroled for a day upon arrival, and then that parole was lifted, and, you know, they've been in the United States for 20 years. Your position is that they are still arriving so they can be put in expedited removal?
Your Honor, are you saying that they were illegally entered the United States 20 years ago and they were given parole yesterday?
No, they were given parole on day one, and then it was lifted on day two, and they've been in the United States for 20 years since then.
I think under the text of the current arriving alien regulations, that would be the case, but I don't know that DHS would actually use its discretion to do so. And while the expedited removal statute, if you read it, says shall, BIA precedent that we cite in our brief gives the ability to apply expedited removal a discretion.
We have to figure, I mean, part of this case might depend on whether that 1997 arriving in regulation is properly interpreting the statute. And you seem on really solid ground with, including because of a lot of the precedents going back 100 or so years, that, you know, if you're on parole, you are arriving, you're entering, we treat you as if you have been detained at the border. But I don't see any of those precedents saying that, you know, if you were detained for a day or paroled for a day and then running around the country out of parole for 20 years, that you're still considered an arriving alien.
Well, Your Honor, at that point, somebody would have been able to, if their parole was canceled, maybe they saw a different type of status. I mean, if they had been in the country that long, I think that that's probably what would actually happen there.
They've been living in the shadows.
But I will say,
you're still think that person is arriving, living in the shadows for 20 years, but not on parole.
Your Honor, I think that here the alien would likely have sought another status, but I will say I think the Make the Road stay panel, two of the judges on that panel had some language about parolees, and parolees enter on the condition and with the understanding that they remain legally at the border. Any connections they make with the United States are with knowledge of their unentered status. People that come in on parole.
You think they were talking about, maybe they were, but were they talking about people on parole or people whose parole was 20 years ago?
Your Honor, I don't think that was considered there, because I think the issue there was that in the due process context, it doesn't matter how long somebody has been here. They still only get, if you came in on parole, you only have gotten, even if it's, I think the Kaplan versus Todd case is one that's long, I think it's 8 or 9 years. There's no additional process than whatever.
I guess you would at least say someone paroled for a day, then released, and let's say 10 years after that somehow got a legal status. I guess you would say that person is no longer an arriving alien.
Yes, Your Honor. If you have a legal status, you would not be subject to expedited removal.
Can you get parole before you show up at the port of entry?
Your Honor, it cannot be granted until you're at the port of entry formally, but they can issue you something that allows you to come to the border to do so. So that was what was going on with the CBP-1 app. And one of the reasons that this is even going on, that there's so many parolees, is that under the parole programs that existed during the Biden administration, there were, I mean, 1 million plus people that came in under these parole programs. There was a mobile app that was created in order to try to have less folks coming in, trying to come in through the southern border. People were able to frankly fly into ports of entry using, and you get approval to do so, and use this app in order to put in their information and the like, and to schedule appointments to be granted parole at a port of entry.
So with I was trying to adapt Judge Walker's hypothetical scenario, but what about, and it sounds like it can't be done with respect to somebody getting parole before they show up at the border, because that doesn't happen. You only get the grant of parole when you get to the port of entry.
That's how I understand it.
So suppose you have a situation in which a person is paroled, comes in the country, and then leaves, and then comes back, but isn't paroled the second time. Then would the arriving regulation apply?
Your Honor, I'm not sure in that precise scenario. I think that given usually parole is only for one entry. It's not an entry into the country. So I think at that point they may be subject. They may be just a regular alien that would be subject under the designation provision if they were caught within a couple of years.
So that person wouldn't be subject to expedited removal if they're paroled. They come, they leave, they come back the next day. Not on parole status that time, and then they're here for 15 years.
And they come back unlawfully through the border. Yeah, in that case, the person, I think the person would be, I think would likely be in a different category. Now, if they're in the system, it might be difficult because they're in the parole system is as the Make Their Own State panel, I think, recognized, like, this parole system is very comprehensive. Like, you would be able to look up the person and they may be seen as somebody who was on parole at the time, but it would depend on what knowledge there was about their status. I think that, again, if they were here for 2 years, if they were here for not able to prove to the officer that they were not here for 2 years, for the prior 2 years, I think they would be subject to expedited removal.
Under the designation part.
Under the designation.
I was just talking about the arriving regulation. Okay.
Yeah, Your Honor. And one thing about the arriving alien regulation that I think this gets at is whatever the scope of the term arriving alien means. I mean, if somebody has been paroled, or if somebody has been in the country for a year unlawfully and then is paroled into the interior or whatever while they're awaiting their removal proceedings, that person would probably would not qualify under the arriving alien provision. They would qualify under the designation provision. To be subject to expedited removal if their parole was canceled, or if their parole was canceled during those prior 2 years.
And that's because the regulation speaks about
the arriving alien regulation specifically speaks to arriving aliens as being as aliens arriving at a port of entry. I'm not saying that the statute couldn't be read broader than that. It's just the regulation for a long time has stated that.
Right. Attempting to come into the United States at a port of entry. Got it. Okay.
Yeah, and that's why I think why our interpretation of the arriving alien regulation is what it, or the arriving alien portion of the statute is partly what it is, because the person goes back to that situation under the parole statute, which is somebody who was arriving into the United States at a port of entry.
Mr. Becker, can I ask you about the government's argument that a 705 stay has to be limited by traditional equitable principles? If we were to agree with that, would that principle also apply to vacater under 706? Does it have to?
Your Honor, the government's position on that is that it would apply to a vacater under 706, but we don't think it necessarily has to, because the language specifically in 705, 705 clearly incorporates traditional equitable principles. For example, the language of 705 is saying that to prevent irreparable injury, a court may issue all necessary and appropriate process to stay administrative action or preserve status and rights. And we think this is very similar language to that the Supreme Court considered in the Starbucks case, where the court was said that similar language about necessary and appropriate just invoked traditional equitable principles.
And so it would be a coherent reading of the APA to apply those traditional equitable principles under 705, and then perhaps reach a different conclusion under 706.
Your Honor, we think that the government thinks that 705 very clearly it invokes traditional equitable principles, and we have also taken the position that 706 should also be limited in the scope of its relief.
But you've said that the language is different in the two provisions.
That's correct.
Those same words, the many words I think in 705 that basically refer to traditional equitable principles are not present in 706.
Yes, Your Honor, this is not a 706 case, but we are, and the government has maintained its position as to 706, but as to 705, we think the language is pretty clear under Supreme Court precedent, invokes traditional equitable principles, and we think one of those principles is CASA's principle, the complete relief principle.
Is your position on the arriving provision consistent with your position on the designation provision, and here's why I'm asking. I think for the arriving position, you say arriving equals paroled. And that can mean paroled even if just paroled in the past as a historical fact and no longer paroled.
Yes.
But for the designation provision, I think you mean paroled does not equal, paroled just in the past. Paroled means having the current status of being paroled. Aren't those inconsistent?
Your Honor, we think the language here is different. So under the designation provision, the language is has not been admitted or paroled. So that present perfect tense, we think here means that it's the provision is looking at whether the person is not subject to expedited removal because it's under the designation provision, which is a broader provision. It applies to a bigger group of aliens than arriving aliens. For example, it would apply to parolees who were granted parole not at a port of entry. They maybe came in illegally and then were paroled pending their removal proceedings.
Yeah, but for the designation provision, you think paroled means currently paroled. Is that right?
Has not been paroled means that they're
Is not currently paroled.
they're not that they're not paroled.
And then for the arriving provision, you think that arriving means currently paroled or not currently paroled, but paroled in the past.
Yes, Your Honor. So this is a little bit different because we're talking about people who are granted parole at ports of entry, I think, whereas a designation provision, I think, encompasses both those groups. So under the arriving alien provision, someone that's granted parole at a port of entry doesn't enter with any sort of expectations that they're able to stay in the United States, and certainly not after their period of parole has expired or that it's been terminated. So if I'm understanding your question, I think the issue here is that that some people may be subject to both provisions and some people may not be, depending on.
It's not so much that, it's more of just sort of like a grammar textualism concern. For the designation provision, you think paroled means past or present. And for the arriving, you think paroled means, for designation, you think paroled requires present, but for arriving, you think paroled can mean past or present.
That may be right, Your Honor, but I'd also take a look at, I think it's the full language in the designation provision has not been paroled. And I think that is a different tense. I mean, I think you could say, I think if the designation provision said something like was paroled, that might suggest that in the past, that parole in the past would prevent you from being subject to expedited
Yeah, it had a past tense verb like was, not a present tense.
Correct, Your Honor.
Ending like ing, as in arriving, which sounds pretty present. And you want that to mean was in the past once paroled.
Your Honor, that's why I think that the term arriving alien is important to consider separately here, because it just is dealing with an entirely different issue, which is whether somebody, I mean, this is just the entry fiction is always complicated because you're trying to think about what position somebody would somebody maintains their position at the border. They're an arriving alien, no matter whether they've been paroled or whether they've, or whether
I get the entry fiction and I'm not averse to it, but like even fiction books end. So
you might be right about this, Your Honor, but we think that nonetheless that both provisions would allow us to subject these aliens to expedited removal.
Okay.
So one final question on something that's a little bit down in the weeds, but I just want to make sure I understand what happened.
Yes, Your Honor.
That in the CHNV designation, the one in the Federal Register.
Yes.
So there's a question about arbitrary and capriciousness and all that. I'm not trying to get down in the weeds of this, but I'm just trying to understand what was intended here. So there's a critical language in the middle column that you're undoubtedly aware of. And it says, to effectuate the prompt removal, the U.S. government may, in its discretion, initiate expedited removal proceedings where appropriate. Expedited removal is available only when an alien has not been continuously present for at least 2 years, the 2 years preceding the date of the inadmissibility determination, and then citing the statute and the regulation that deal with the designation part. So I understand that part of your argument that there's no inconsistency there because that has to do with the designation part, not the arriving part. But then what I'm not following is the next sentence. The next sentence says, if DHS were to allow CHNV, the CHNV parolee population to remain for the full duration of their 2-year parole, DHS would be compelled to place a greater proportion of this population in Section 240 removal proceedings to effectuate the removal. So why that just doesn't seem true if you think that you have the authority that you say you do under the arriving regulation.
Your Honor, I think maybe DHS, I think here I see with the word compelled. I think that what is going on here is that DHS is only applying expedited removal to the folks for the prior 2 years under the designation provision. The arriving alien regulation is broader authority. And I think that my best explanation for it is that this is really based on what the statute allows. And they could have been applying it under the arriving alien and just regulation and just we're not doing
It's not compelled. DHS is not compelled. It says that DHS would be compelled to place a greater proportion in Section 240 removal proceedings. But if DHS has the authority under the arriving regulation, then it wouldn't be compelled because it could use the arriving regulation. Unless I'm misreading this.
That may be right, Your Honor. I think under our argument now, our argument is that they could use the arriving alien regulation for people whose parole was revoked. I think that, or for people whose parole was revoked, and I guess even people who were still on parole.
Well, the relevant population is the CHNV parolee population to remain for the full duration of their 2-year parole. So what the DHS appears to be saying in this Federal Register notice is that if DHS allowed those folks to stay for the full 2 years, then they'd be compelled to use something other than expedited removal. They'd have to use 240 removal. But as I understand your argument, that's actually not true because the arriving regulation would still give the authority, even for somebody who's here for the full 2 years. It would still give DHS the authority to use expedited removal as to that population.
Your Honor, under the arriving alien regulation, DHS would be able to use that as to that population because that population that population would be former parolees. They're people who would have CHNV only allowed granting parole you wouldn't have been able to get. My understanding is that under those programs, you actually wouldn't have been able to get that type of parole if you had been in the country and entered illegally. So I think that's correct.
Right. So okay. So I just want to make sure that this says would be compelled, but actually under your position in the case, DHS wouldn't be compelled. It's not necessarily saying there's a legal claim that arises.
Yes, Your Honor.
I just want to make sure I understand.
Yes, Your Honor. Our position is that these individuals would be subject to expedited removal, even beyond the 2-year period.
Okay.
I think 2 questions. One is a follow-up on that, and then one is a follow-up to something earlier. The follow-up on this is, let's say that I look at this sentence that the Chief Judge is describing, and I think it was probably meant to talk about what the designation provision allows and doesn't allow. But it is inaccurate as written because it says that something is compelled, which the arriving in provision allows. Let me know if you're following.
Yes, Your Honor, I'm following.
Okay. Then what is your opinion about what our court in this posture should do about that?
Well, Your Honor, I think a lot of plaintiffs' arbitrary and capricious arguments that relate to these two different authorities sort of miss that. I think they're basically arguments about what the statute and the regulations allow. I think there's other places in the CHNV termination notice that specifically reference the arriving alien regulation. I'm looking at 13612. In the absence of any subsequent application conferring an immigration benefit or status, and upon termination of parole, such alien remains an arriving alien and goes back to that status. So I think that while this notice may not specifically state the authority to use expedited removal as to those folks, it does state that they would be arriving aliens and they would be subject to expedited removal. Even beyond that, whether DHS was going to do that or not, or would do that, I think is a different question. And I think that there's subsequent guidance that specifically states that the arriving alien.
Yeah, I mean, let's say I agree with all that. I think I didn't quite get the answer to my question. What are we supposed to do? If there's something here that's inaccurate, it conflicts with other accurate sentences that you've been referring to. What is, I mean, your answer can be we should do nothing, but I'm just wondering what.
I think, Your Honor, as to that provision, I don't think plaintiffs have really alleged any sort of harm from that as a result of not being.
I think their theory is that maybe because of some Supreme Court precedents, the government needed to address plaintiff's reliance. Part of how they addressed plaintiff's reliance was saying, well, we, the government, have an interest in moving fast. So far, so good. Our interest in moving fast is this sentence. Well, if this sentence is legally incorrect, then I think the plaintiffs would argue that weakens your explanation for why you needed to move fast at the expense of their reliance. And again, I'm not saying this means we should affirm the stay. I'm just wondering why not?
Well, Your Honor, I think it's probably appropriate for the court to clarify that like there is the ability to remove aliens under the arriving alien regulation. I just don't think that DHS was necessarily relying on that before. And I think plaintiffs make a lot of claims about that.
So I think your argument sounds like we should affirm the stay in spite of the sentence the Chief Justice was reading, because even if it is inaccurate about what is compelled, it's harmless error.
I think that's right, Your Honor. I don't think that this affected.
Maybe this is about what you're going to say if I let you finish your sentence. But why is it harmless error?
Your Honor, this is harmless error here because the plaintiffs don't. The plaintiffs are not alleging any particular harm from DHS limiting itself to that couple of year period. They're not alleging that this is not a case about the parole termination notice and whether that was appropriate at all. I think that they're alleging that their harm here is from having expedited removal applied to former parolees. And I don't think that this isn't a challenge to the notice generally on why the parole programs are being terminated. I think this is just a different case, so it's harmless error as to this case, certainly.
Okay, I'm going to change topics, but if you have a follow-up.
Yeah, I'm also not, and then you just one interjection quickly because when we can ask the plaintiffs, I'm not recalling. I could be off about this, but I'm not recalling that either the plaintiffs or the district court isolated this particular sentence as opposed to the previous sentence, which I think was doing most of the work for the arbitrary and capricious argument. That may be perfect too. There's a question as to whether this one was put into play, but I just wanted to make sure that I understood what the government's position was on this, given the apparent language of the sentence.
I'm grateful for the clarification because I had underlined both of those sentences. So I think, hopefully, for your sake, you need your answer about the sentence I asked about and the sentence the Chief Justice was asking about to also be the right answer for the sentence. Do you see where we are? It's 13619 of the Federal Register.
The middle column. the set of sentences that have been kind of the focus of the, at least one of the focuses of the arbitrary and capricious argument. That paragraph that begins, DHS has concluded the potential reliance interests, and then the sentences down a couple sentences from that.
Oh, yes.
Right after footnote 71.
To effectuate their prompt removal, the U.S. government may have discretion to initiate expedited removal proceedings where appropriate.
Right. And then the sentence, the one I think that Judge Walker and I are focused on are the sentence after that, which is if DHS were to allow the CHNV parolee population to remain. It's that sentence where the second clause is DHS would be compelled to place a greater proportion of this population in Section 240 removal proceedings.
Just to tweak that clarification, Mr. Becker, the sentence that Chief Justice just read that begins if DHS, but then there's one sentence right before that that begins expedited removal.
Yeah, I think the district court was focused on, if I remember right, it was focused on that first sentence, but yeah, because the district court was saying that we were citing the incorrect, the two documents cited two different legal authorities because and I think that was the focus of what the district court was getting at, was that there was that the termination notice was essentially not citing the arriving alien authority, but the email that the enforcement email was citing the arriving alien authority and noting that it could be available for there was no time limit on.
Yeah, I thought the point was that this sentence that Judge Walker has helpfully highlighted, the expedited removal is available only when an alien has not been continuously present in the U.S. for at least the 2 years preceding. That was the subject of the arbitrary and capricious conclusion on the theory that this says only has not been continuously present for at least the 2 years, but then there's other documents that say there's no time dimension. And your response to that was, well, this has to do with the designation authority, and those other documents have to do with something as to which there's in fact no temporal limitation, because that's the arriving authority as to which there isn't. And that I understand that argument. I guess I was focusing then on the sentence that follows it. And on that one, I think you're acknowledging that that sentence is not fully accurate in saying that DHS would be compelled. And then there's the question of whether that matters.
Yeah, I think that's right, Your Honor. I think that under the arriving alien authority, they would, under our position in this case, they would be able to apply expedited removal.
And one more time, why does it not matter that the sentence is wrong?
Your Honor, plaintiffs here are not challenging I don't think are really challenging the reliance interest, that we didn't consider reliance interest in actually terminating the CHNV programs. I think what their argument is that it was that between these couple of documents, it's just not clear what legal authority we're relying upon.
Maybe. Okay, do you have more questions? Okay, let's go back to the merits a little bit, unless the reasonably explained argument. Let's say that, well, if you have an argument that at first I found appealing, and now after I thought about it a little more, I wasn't as persuaded by it. So I'm going to tell you what the argument is. If you want to be persuaded by it, you can tell me why you think I'm wrong. And then it might affect what remedy you would be entitled to. You have a line in your brief that says the 1997 regulation has not been challenged. So we take it as correct. And of course, it hasn't been challenged because it can't be challenged. 60 days have passed. Because the 1997 provision can't be challenged, these three guidance documents can't be challenged for applying the 1997 regulation. And so even if the 1997 regulation were unlawful, there still should be no stay in this case, because the three documents challenged were I'm trying to think which argument that falling thing might be a metaphor for, but I'll let it go. The three documents can't be challenged because they rely on a regulation that can't be challenged. Here's why I think that's probably wrong. Imagine the 1997 document had said something that was completely unconstitutional. You know, it says the government can run around summarily, taking people's property whenever it wants to. Okay. And then, okay, that document can't be challenged because of the 60-day time limit. But then now in 2025, the government issues 3 documents that instruct government officials to go around summarily taking people's property. And they say, and we're doing it in reliance on that 1987. I think those current 2025 documents would be instructing government officials to do something illegal. Something that the 1997 regulation said the government could do, but because the 1997 regulation was wrong, these current documents are instructing the government to do something illegal. And since it's within 60 days to challenge these 2025 year documents, they could be challenged and ought to be stayed and eventually vacated if they are telling the government to do something that the Constitution either prohibits or that a statute does not authorize. So am I right? I think I'm right about that. And if you think I'm wrong, tell me why.
Your Honor, I think I think in that case, if they're arguing there's some sort of unconstitutional violation, there may be some sort of
Not even necessarily unconstitutional. I mean, let's say that the 1997 regulation says a statute allows us to do this thing, but the statute doesn't allow it. And so in 2025, the government issues 3 documents telling government officials, go do this thing that in 1997 we said a statute allows, but there is no authority for the government to do this thing in 2025 because no statute allows it.
Well, Your Honor, I think that under 1252 E3, which is what plaintiffs are bringing their challenge under, it's a facial challenge to these documents. I don't think that prohibits aliens from raising in their individual expedited removal proceedings that the document is unlawful. So I don't think this is the situation where we actually have that issue where you just could never raise this challenge. And I'll say that district courts are, as I think we've described, considering challenges to the arriving alien regulation and whether it's appropriately as applied to these aliens. This is, I think, something that comes up a lot in this court with regulations. For example, SEC regulations you have to challenge within 60 days and the like. And the question is, after a certain amount of time, after those 60 days, what do you do about that? If those regulations were totally unconstitutional, you would be able to in individual proceedings.
I get that these plaintiffs could not ask us to stay or vacate the 1997 regulation. Couldn't be clearer. But they can ask us to stay the 2025 documents. And if those 2025 documents tell government officials to do something illegal, I think a court is supposed to stay that, right?
If those documents are simply applying the 1997 regulation, I mean, I think that under our position in this case, because if the 1997 regulation says the same thing as those and I think that's what you're getting at, Your Honor. Is that correct? That the 1997 regulation is totally unconstitutional? If the 1997 regulation is totally unconstitutional and these documents are just simply applying that regulation, I think that really the only relief plaintiffs could get is by going into their individual proceedings and alleging that these are unconstitutional. I don't think that this isn't a case where there would not be any sort of judicial review for such a thing. I mean, I think this just happens in many other contexts as well. It's just that you end up bringing it in an as-applied context rather than in a facial challenge.
I thought the government's position, though, is that even in an as-applied challenge, the time bar would apply because it's a statute of repose. I mean, that was the government's position in Make the Road. Your position now is that the 60-day time bar doesn't apply in individualized proceedings?
Well, Your Honor, what I'm saying is that I think under a lot of what district courts have been doing, they've been considering whether these aliens are subject to expedited removal in their individual proceedings.
That's permissible under IRERA?
I don't think so, but I think plaintiffs would have to bring an individual case in DC to challenge those.
You said that there would be judicial review available for an as-applied challenge, even if the 60-day time bar had run. You said this is a situation where judicial review is available. Not that district courts are saying it's available. You're saying that it is available. So I'm just wondering, has the government changed its position on what the
No, I don't think
statute of repose means?
I don't think the government has changed its position. I think that in that type of situation, I think that that aliens would have to bring some sort of ultra vires or some sort of other mandamus action or something of that nature. There may just not be available regular judicial review.
I'm pretty confused. Go ahead, sorry.
Then we're back to what Judge Walker asked, which is that then the government's position is that even if the underlying regulation is just patently unlawful, we just stipulate to that, then the directives applying that regulation to individuals even just can't be challenged.
Those individuals would have to challenge that in their individual removal proceedings. And I think that's really the only way.
Is that consistent with the circuit's opinion in MMV about the 60-day statute of repose?
I mean, that consistent with MMV, I don't know that the alien would be able to bring. I mean, the alien certainly couldn't bring a facial challenge to these regulations as
There's
being
very little an alien in expedited removal is allowed to argue
That's
to a
correct.
court. I don't think this is one of those things.
Again, I think they would have to bring some sort of, I mean, they could try, if it was a totally unconstitutional regulation, they would have to bring some sort of ultra vires action or something of that nature, that this is totally, and that
What would
would
the
be.
cause of action for that be?
No, I'm saying that I don't think they would have a cause of action to bring it.
Okay,
So there wouldn't be judicial review.
Yes, I think that's right.
I'm just going to disagree. I think that if the 1997 regulation said you can apply expedited removal to, for example, someone lawfully here on a student visa, I think, and then if a 2025 document says start putting people on student visas in expedited removal, that the 2025 document could within 60 days be challenged according to the cause of action here, and a court could stay it and vacate it. But you don't have to agree or disagree with that. That's what I think. And then if that's correct and you can't totally rely on the 1997 to totally absolve yourself of the merits here, then you might still win on the merits if the 1997 regulation is correct. Because here's where I very much agree with you. I think if the 1997 regulation is correct, you haven't done anything illegal in these 2025 3 documents, because all they're doing is just applying what you said you were going to do in 1997. So that then raises the question, was the 1997 regulation correct? And it does seem to me like it was correct. Except I'm not sure that and someone who's no longer on parole and has been here longer than 2 years can be subject to expedited removal. I know you disagree. We already talked about why you disagree, and you might be right. But if you're wrong and I'm right, what do you think this panel in this posture on your appeal from the stay should do? Assuming that I'm correct, that there's a sliver of people out there that you are saying you have the authority to apply expedited review to, who you don't. And those are people no longer on parole who have been here longer than 2 years. What should we do?
Your Honor, I don't think there's anything to do, and that I would just reverse the stay, because the plaintiffs challenged the 1997 regulation in their complaint, and the case could be sent back to district court, and that can be litigated there.
But you, in what I'm asking you to assume, the 3 challenge documents are telling government officials to do something that it is illegal for them to tell government officials to do. And that would be put into expedited removal people who are no longer on parole and who have been here for longer than 3 years. And I'm asking you to assume that that is unlawful, and that there is a cause of action that would allow plaintiffs to get a court to stay that and vacate that part of it. And now I'm asking you, in that assumption, what do you think we should do?
Well, if there is a cause of action, and I guess there is standing here to challenge that, I mean, in that case, then I think that would raise what the meaning of arriving alien is in the statute, which I do think is raised in this case. So the court would have to interpret what arriving alien meant in the statute. And I think that is raised by the documents themselves. But the issue here is that plaintiffs didn't challenge the regulation. That includes a definition that I think encompasses people who are here for longer than that time period that you're.
Okay, and let's say that I think, okay, based on the merits, I think I'm just going to vacate. I'm going to uphold the stay. and you say, no, even if I think what I think about the merits, I should still not totally uphold the stay. I should only uphold part of the stay because.
Your Honor, I think in that case, I think the vast majority of people who this would be applying to, given this is is about the CHNV termination parole programs. I don't even know that the kind of outer bounds of what arriving alien would qualify as is even really raised in this case. So
it's possible that none of the people that I'm concerned about need this stay. I
don't think that plaintiffs have alleged any individual member that has been here for that long that needs to be that somehow needs to stay or has been here for 10 years. I don't think that's what the focus of the case has been on. It's on the cancellation of these these parole programs, and whether those folks can be subject to expedited removal.
Maybe when it's the plaintiff's turn, they can say if they disagree with that last thing that you said.
Yes, Your Honor.
Make sure my colleagues don't have additional questions at this point. Okay, we give you a little time for rebuttal.
Thank you, Your Honor.
Done.
Yeah. I'm shorter.
Do that right.
Good morning, Your Honors, and may it please the court. Esther Sung for the plaintiffs. Congress established the expedited removal system in 1996 for people who arrive at our borders and who have entered illegally and have no entry documents. Now, those aren't actually my words. Those are the words the United States government offered to the Supreme Court in their opening statement in United States versus Srinivasan. And the plaintiffs here today simply agree with that plain text interpretation of the statute. The plaintiffs, it's the plaintiff's position that that plain language of the statute, the structure, the legislative history all make clear that the expedited removal authority applies only to two distinct and limited populations. First of all, people who are arriving in the United States without proper documentation. And second, people who have come to the country illegally, of course, subject to the designation of the Secretary of Homeland Security. But people who have come to the country illegally and who have been here physically present in the country for no more than 2 years. And parolees, people who have come to a port of entry, who have been inspected and who have been paroled into the country, do not fit in either of those two populations.
Before we go down the road on the merits, can we just talk a little bit about these threshold questions, about the implications of the fact that for the interim stay purposes, as opposed to at the end of the day, you haven't sought to stay the regulation? It's just the government's position, obviously, is that if you haven't sought to stay the regulation, in fact, your complaint presumes that the regulation allows expedited removal, then how can you show redressibility, or how can you avert an inability to show irreparable injury if there's still authority to effect expedited removal as to this very population under the regulation?
Sure. The government does want to direct the court's attention to the regulation. And because of that, I think the import of this appeal is not what it once was. And we've actually filed a motion for summary judgment in the district court that encompasses our claims relating to the regulation, and that's currently pending. The government moved the district court to hold that motion in abeyance pending the disposition of this appeal. We opposed that, and the district court indicated that she wanted to wait to rule on that motion, to hold our summary judgment motion in abeyance.
Right. I mean, because it was your choice whether to seek a stay of the regulation as part of the interim stay application, and you opted not to, and could be for all kinds of reasons, including there's a timeliness issue, obviously, but for whatever reason, what we have before us is an interim stay only of the directives, but not of a regulation that your complaint itself assumes can be used to affect expedited removal. So where does that leave us with redressibility?
I think
or
that,
injury?
well, where that leaves us is the question is sort of whether the district court properly found that there was redressibility as to the challenged actions with the record that the district court had before it at that time. The district court and frankly, the plaintiffs could not have predicted that the government would in fact change its position as to the regulation, because the record before the district court was very clear that, and Your Honor, Judge Srinivasan, you pointed this out, there is a difference between the extent to which expedited removal was being pursued based on just the regulation and the regulation plus the directives. And the record is very clear that when we were in a world where it was just the regulation, the government was not, in fact, pursuing expedited removal of essentially humanitarian parolees, people who had been paroled at a port of entry and inspected and paroled into the country. The record before the district court was that there were only 2 instances of individuals being paroled into the country.
So I'm familiar with that record. And sorry, just one follow up. And I guess what I'm wondering about that is, let's just stipulate that that's the historical record. And that is definitely what the district court relied on to say that redressibility had been shown. But this just gets, I think, to the question of enforcement priorities. If the regulation hadn't been used, but it could be used, which I think your complaint presupposes, in a broader set of instances than it had been used, and then there's a new administration that just has different enforcement priorities and wants to max out on the use of the regulation, then the fact that there's been an uptick after the directives wouldn't be altogether surprising, because that's a reflection of the enforcement priorities having shifted and an increased emphasis on using the regulation. And if that's the case, then I don't know that the right baseline is just what was the case beforehand, because what was the case beforehand was predicated on a different set of assumptions about the aggressiveness of the exercise of enforcement authority than might be the case now. And so then one would say, well, if the regulation still could be used to the same extent as the regulation plus the directives, the fact that it wasn't being used to that extent at a prior period wouldn't necessarily tell us if it still would be used now to that extent. And if the burden, you're right that we have to address whether the district court, to affirm the district court's conclusion as to redressibility, but the burden is on the plaintiffs to show redressibility. So what we have to address is whether the district court correctly concluded that redressibility had been shown based on what you'd put in the record. And I guess on that set of assumptions, then why is there something in the record from which to conclude that, given what the state of affairs is now with respect to enforcement priorities, we would expect that there would be a meaningful delta between what exists under a regime in which there's just the regulation and one in which there's the regulation plus the directives?
Well, I think first, I have a couple of responses to that. First, the district court found as a factual matter that the defendants had failed to rebut evidence from the plaintiffs that the underlying regulation would have been used, would have had the same result if the challenged actions hadn't issued. And I think as a practical matter, although I can't presume on the part of the government, to the extent that there were changing enforcement priorities, the challenge directives effectuated that, implemented that, and they are challengeable under 1252E3. But I also think that this gets to sort of the speculation argument, right, that you were discussing with my colleague here. And I think that this situation is a little bit different than some of the third-party cases, for example, in the nuclear regulatory case that the government cites, because you do have a very clear track record of sort of with the regulation and with the regulation with the directives. And the district court did not err in finding that staying the directives would have some effect. And in fact, it did. And you can tell this from the positions that the government took in its briefing before the district court. The district court, the government said in opposing the motion for stay that the relief that we requested would prevent DHS from applying expedited removal to potentially hundreds of thousands of paroled aliens. And of course, now they're taking a different position. They have changed position here. But that doesn't mean that the district court was wrong in finding redressibility on the record that the court had in front of it, or that the district court's stay doesn't have any meaning or import. And I think it's actually very similar to the tariffs case that the Supreme Court just decided, in which, as you know, the president turned around the very next day after the Supreme Court's decision in Learning Resources and reimposed basically the exact same tariffs based on a different legal authority, but something that the president had always telegraphed that he was going to do if the original tariffs were ruled unlawful or unconstitutional. And in that instance, I don't think anybody would argue that the plaintiffs who challenged the original tariffs and Learning Resources and the related cases didn't have standing.
But they might have a claim as to that. They might have an argument as to the other use of authority. And I think what makes this case different, or at least complicated, is that your complaint itself presumes that the regulation could be used to effect expedited removal. I mean, do you doubt? So let's suppose that we just agree, for purpose of this question, that there's a downtick because of this stay of the directives, but do you dispute that the regulation on its own could be used to the same extent?
No, I don't dispute. But the point is that the stay did have that effect. And that is why the district court didn't err in finding, with the record before it at that time, that there was redressibility and that a stay of the challenge directives would redress part of the plaintiff's injuries.
I've been asking enough.
Sorry, when the question is, ramping up or ramping down enforcement discretion, it's very hard to say that, like if there is underlying legal authority, which you accept that the regulation provides legal authority for this, how can we say that the stay itself is affecting whether there are more or, fewer or more people put into expedited removal? I mean, it's a matter of discretion.
It is, but enforcement discretion, as you can imagine, is a huge enterprise. It has many moving parts. And I think,
which is exactly why it's hard to show redressibility from a single stay when the underlying legal authority persists.
But I don't think that's correct. The record shows that when you just have the regulation and all the immigration enforcement officers in the country can, again, exercise discretion as they will, the record is very clear that when that was the state of affairs, there were only two instances, at least. There
were different enforcement priorities in previous administrations. I mean, this administration has made very clear what its enforcement priorities are, whether there is a document that says it or not.
Yes.
The challenged actions here are just statements of administration policy of how discretion will be exercised.
Yes, but I think the point is enforcement discretion to be communicated and implemented in some way as a practical matter. I mean, enforcement officers can't divine this from telepathy or something like that. And so that's what the challenge directives represent. They represent new enforcement priorities by the administration, and they communicate to enforcement officers, you have this, please.
But how is that? I mean, how does that establish redressibility for purpose here?
Well, I think the district court. I don't think that the district court erred, and certainly the government hasn't disputed or shown any error in the district court's finding that it was the challenged actions, the challenged agency actions that are the cause of the harm to the plaintiff's members.
It would be an independent error that the district court made by suggesting that the burden is on the government.
Well,
right, the burden is on the plaintiffs to show redressibility. The burden isn't on the government.
Yes, and the record that we submitted that was not disputed by the government, I think that's maybe where the district court's language is coming from. But the record that both parties developed before the court is very clear that after the challenged agency actions were issued and implemented, that is the cause of the harm to the plaintiff's members. There's a very clear before and after picture, I think, in the record, and so as a result, I don't think that it was an abuse of discretion for the district court to conclude that staying the challenged actions would, at least in part, redress the plaintiff's harms. And I think what we have here, frankly, is a little bit of whack-a-mole, right? There, what we thought we were dealing with was sort of 3 directives that were causing harm to the plaintiff's members, and so we've whacked all 3.
Maybe that was a litigation error to not also raise the regulations for the purposes of the stay, right? So that's not something that we can fix.
But we've whacked those 3. But then I point out that, again, it's a change in position that the government is now taking, that it can rely on the regulation independent of the challenged agency directives to apply expedited removal to parolees. And so the mole is popping up in the 4th hole. But the district court, again, did not err in whacking the mole, as it were.
But plaintiffs agree that there is the 4th mole. And you agree that it's there. You just chose not to whack it down in the stay posture. That's not the government's fault. You agree that the regulation allows this type of actions. And so
I don't mean to belabor the metaphor too much, but there wasn't a mole popping out of the 4th hole at the time that we moved for the stay from the district court. It was and it's sort of a 2020 hindsight thing, but at the time when, the directive from the administration was to ramp up to 3,000 apprehensions per day, et cetera, it seemed very clear at that time that what was driving this, what was causing the harm to the plaintiff's members, was the 3 challenged agency directives. That was what needed immediate
this is
address.
part of the problem, though, with litigation attempting to use federal courts to control enforcement discretion. Because, say, the secretary just announced, didn't write it down, just said, well, okay, I direct people to, enforce the, use the 1997 regulation
Perhaps,
for greater enforcement of expedited removal.
Perhaps, but
even plaintiffs' view, that would be permissible.
But Congress did make these types of written policy directives challengeable under 1252E3. I think precisely because expedited removal is a very draconian enforcement action. It's very stripped down. There's no process. And so there is review available under 1252E3. And we've brought the suit in a timely fashion. And what was causing the harm to the plaintiff's members, again, at that time, what was the challenged agency directives. And I would point out that after unfortunately, it's not in the joint appendix, it's in the record below at ECF 53. There was sort of an interim period during which the district court had issued its stay, but this court had not yet denied the stay pending appeal request from the government. And in that sort of interim period, we did bring the government's attention to an individual parolee who had been placed in expedited removal. And we suggested that this wasn't appropriate in light of the district court's stay. And the next day, the government wrote back to us and said, this person has been taken out of expedited removal and has been placed in regular removal proceedings.
Government's, perhaps what they would now call over-compliance of the stay, is evidence against them?
Well, I think it's an indication that they understood that the stay had effect and that it did redress the plaintiff's harms. I think that's the question of sort of what record did the district court have before it? What was causing the plaintiff's harms, and what would redress the plaintiff's harms, at least in part?
You filed the stay on what day? I think it was June 11th. And are you saying that you didn't know at that time that the 1997 regulation?
No, that's not what we're saying. But what we're saying is that, again,
It was the 1997 regulation was injuring your clients at that time, correct?
I suppose, yes, but the point
I
is,
think you would have to say yes, because you amended your complaint that day to
Yes.
challenge 1997 regulations. You can't.
yes.
challenge regulation that you don't have standing to challenge.
No, I understand that. Yes. But again, I think here for purposes of redressibility is that the relief doesn't have to address all of the plaintiff's injury. It just has to address part of it.
So I've been
And-
curious about that too. And I know the district court said that, and it makes sense if you suffered $1 million in damages and you can get 10,000 of those, that's redressibility. Part of your injury has been redressed, but I would think like being put in expedited removal is sort of a binary thing. You're either in it or you're not. So I'm not sure how you could get partial redress when your injury is being put in expedited removal.
It's partial redress in that the government was clearly relying on the challenge agency actions to subject people to expedited removal. What we want to do, like what the end goal of this litigation is, right, is to remove all the sources of authority that the government is relying on to say that parolees can be subject to expedited removal.
That may be
because
what you want to do at the end, but that's
Yes.
not what you try to do in the stay.
This is true, but that's because, again, back in June of 2025, the world was, that as we understood it, was sort of regulation, essentially de minimis application of expedited removal to parolees. Regulation plus directives, a huge explosion in
I mean, if the
enforcement.
regulation was only causing de minimis injury, I'm not sure why you amended your complaint to challenge it.
Well, it's still injury. And then again, what the government has now changed position and is saying, oh, well, now that the challenge agency directives have been taken off the table by the district court's order, we can still rely on the regulation. But that is not the position that they were taking before we filed the lawsuit and before we moved for the preliminary relief from the
You
district.
don't have, I know that I'm not asking for a name because I take it some of the members, if not all of the members of your organization are proceeding under anonymous names. With that in mind, again, I'm not asking for a name. Can you identify someone who has been put in expedited removal who would not have been put in expedited removal absent actually no, someone who has not been put in expedited removal, but would if this stay is lifted.
Well, certainly the declarations from the organizational plaintiffs talk about and identify some members who express harm, who've expressed fear of being subject to expedited removal. And again, all of the consequent problems that attend that, they're afraid to leave their house, all of that.
I think that I don't doubt that the fear is real and that the fear is important. I'm wondering, as a matter of redressibility under the third prong of standing, it's your burden to show a likelihood of redressibility. So I think you need to show at least a 51% likelihood that this stay is the reason that at least one person has not been put into expedited removal. Who is that one person?
Obviously, I think that, again, it goes back to what the state of affairs was at the time when we moved for relief and when the district court, again, with the record that it had in front of it, what the district court assessed to be redressable. And because the challenge agency actions are what was driving this increase in pursuit of expedited removal against parolees, certainly following the district court stay, everybody breathes a sigh of relief. Because this very obvious source of authority that the government had been relying on to subject parolees to expedited removal had been stayed.
I get all that,
And
but I do think you haven't come close to identifying the pseudonym of the person I'm asking for.
certainly if we can look it up in the declarations. If you'd like to, we can submit something to the court to identify these people. There are definitely people identified in the declarations of the plaintiff organizations who have parole, CHNV parole or CBP1 parole, and who are concerned, especially because of.
You don't have to prove to me that they're concerned. I think that has been established. If you want to make a filing, that's your prerogative. It's not from. I'm not asking for it. Okay. And I guess we would also have to consider whether it's too late at this point because the burden was on you to do it before now. But what you would need to show is not that someone has a fear. You would need to show a likelihood that the stay is the reason that that person has not been put into expedited removal, and that if the stay were lifted, there's at least a likelihood that that person would be put into expedited removal. And I think in your defense, it's not your fault that you haven't shown it. I think there's a pretty good chance that it just can't be shown. But that would mean you don't have standing.
I think that part of this is due, in fact, to the shifting position that the government has taken. It's really only after this court denied the motion for stay pending appeal that they then started saying, you know what, don't worry about, we can rely on the regulation. I think this is what.
The underlying state of the legal world is not a shifting position. There was always, the regulation was always there. And plaintiffs agree that the regulation can subject these folks to expedited removal. So this idea that there's a difference of degree there, I couldn't find any case suggesting that redressibility in part can be satisfied where there's like a matter of degree and discretionary government action. Can you point to any case where that's the situation? I mean, because your suggestion is if 100 people would do expedited removal under the stay, that number is something less than 100. Which redresses some group harm in part.
Well,
but questions of degree, I'm not aware of any case where we've suggested that. I mean, I think Judge Walker said if it's $1 million and it's $10,000, well, that makes sense. You're getting some of what you're seeking. But this matter of degree, it's a matter of enforcement discretion as a matter of degree. How does that establish redressibility?
Well, I think
maybe plaintiffs made a mistake in not challenging the reg for the stay. That doesn't account, and that's not a matter of the government's shifting position. I don't know why you point back to that.
Well, I think that it is. I think that what causes fear in the plaintiffs' members and what actually prompted the apprehension of some of the plaintiffs' members and placement in expedited removal was the challenged agency actions and not the regulation. And again, the record is clear sort of what happens when you just have the regulation and what you have when you have regulation plus challenged agency actions. And I think that I don't have a case for you on sort of scale, but certainly this court has held that if the district court's account of the evidence is plausible in light of the record, viewed in its entirety, then it should not be reversed on appeal. And that's what the district court had in front of it. The district court could not have predicted that following its stay and following this court's denial of the motion for stay pending appeal, that the government would then begin relying actively on the regulation to subject parolees to expedited removal.
But you agree that they can. So
yes, but the record shows that they didn't. The record shows that they didn't. And I think that's
a matter of discretion, not as a matter of law, as a matter of discretion.
Yes, but I think that this is what Judge Walker was getting at when he was discussing document society with my colleague here, right? It's a question of whether, certainly the authority was always there, but sort of, again, looking at the chilling effect, I guess in that case of sort of the enforcement on doc society, and I guess it was their members and so on. I mean, it's again, the record is very clear that sort of harm coming from just enforcement of the regulation, again, de minimis, harm coming from enforcement.
Okay, so that's your only answer.
So,
I mean,
yes.
we're just going.
Can I ask you this question? If suppose, and you'll resist this, understandably you would, but suppose that the reason that the stay gets overturned, but the reason it gets overturned is that there was no request for a stay of the regulation. And that created a gap either for redressibility purposes or for irreparable injury purposes. And that means that the stay can't be sustained. If it goes back down, would you immediately then ask for an interim stay, but then tack on that you're seeking an interim stay based also on the regulation?
Well, we do have a motion for summary judgment already pending before the district court that does encompass our claims relating to both the challenge agency actions and the regulation. And so we have essentially teed up.
But so that's going to take some time to unwind and be resolved. And I guess the question is, and maybe your answer is it's not going to take that much time, so an interim stay just doesn't matter. But if that's true, then
Yeah.
an interim stay anyway. And so I think the question is, I'm just asking a practical question.
Mm-hmm.
Would there then immediately just be, depending on, of course, how the district court reacts to it, but would there immediately be a request for an interim stay, but this time tacking on that you're also seeking to stay the regulation while the litigation unfolds, and then the district court would have before it whether that kind of stay was warranted in light of whatever we would say in sending
Sure.
it out, hypothetically.
Right. I think we'd have to assess sort of a matter of person power. But if I had all the resources in the world, yes, I think we would to prevent parolees from being subjected to expedited removal unlawfully in violation of the statute.
And then can I ask you this other question, which is, for at least for me, the notion of applying redressibility just as to interim relief is a new animal. It may be right. It may be, and I haven't understood you to actually resist that proposition, because I think both parties are operating on the understanding that redressibility needs independently to be shown as to interim relief. That may well be the case, and it seems like both parties are in alignment on that. We still have to do our own thinking about that. But I'm not sure practically how much it matters at the end of the day, because it then surfaces at the back end in terms of irreparable injury anyway. And I guess my question is, as to irreparable injury, apart from redressibility, if the authority still exists, regardless of the directives, the authority still exists because of the regulation, then can you show irreparable injury given that there's still at least the possibility that the regulation could be visited on your clients based on something that's not being challenged for purposes of the interim stay?
Yeah. I mean, I think as a practical matter, first of all, the record does show, and this is going to get back into my discussion with Judge Rao, I'm afraid, but that there are people who are plaintiffs' members who are subjected to expedited removal pursuant to the challenge agency actions when they shouldn't have been. And if they hadn't been subjected to expedited removal, they would have continued in their normal Section 240 removal proceedings. They would have been with their family. They would have had access to all those things.
I think I understand all that. And I guess it seems to me then your position is, and this is totally fine, this may be your position, is that there's no difference in what you would need to show either to establish redressibility or to establish irreparable injury. Either way, it's going to turn on whether, for purposes of the interim stay, either way, it's going to turn on whether the world in the absence of the stay of the directives would look the same as the world if the directives remain in place, because notwithstanding the existence of the regulation, there's no difference between irreparable injury at the back end and redressibility at the front.
Well, so if we could, if the government were forced to articulate the grounds that it was relying on to place someone in expedited removal, perhaps we would have a difference here. But of course they don't state that. They haven't taken a position when we've asked them the basis for putting someone in expedited removal. But
maybe I'm not understanding that. I thought the basis for placing parolees and expedited removal is all the merits of the case.
Well, what I mean is, based on our understanding, speaking to plaintiffs' members, and again, the record showing that the government wasn't attempting to subject parolees to expedited removal before, when it was just the regulations.
Oh, I see.
And it's now
just under the regulation.
right. It's our understanding that people who were caught up in the courthouse sweeps in the nationwide blitz, as it were, and being subjected to expedited removal last summer, essentially, that was pursuant to the challenge agency directives. And then it's our understanding that following this court stay and this court's denial of the stay pending appeal request, they've started relying on the regulation instead. And I do think this gets to sort of the whack-a-mole and the partial redressibility. Like, what we are ultimately trying to do is to remove all of the sources of authority that the government might rely upon to subject parolees to expedited removal. And the district court's order has taken care of 3, essentially, and we're moving now, especially because the government has changed its position on how to enforce and implement the regulation on the 4th. And that's in the motion for summary judgment pending before the district court.
If we were to just affirm, say it was a single sentence.
I would say, great, thank you very much, Your Honor.
I thought you might like that. Would you seek a stay in the district court of the 1997 regulation?
That's a good question. We did contemplate that, but we figured, especially because it's sort of, we did contemplate that, but what we decided was sort of the most efficient avenue was to move for summary judgment. Just to tee it all up for the district court. We have an evidentiary record that we've put before the district court. And again, thinking about sort of human resources and how much time things take, we just figured moving for summary judgment would probably be the most effective and efficient use of our.
What if the day, and I think you're gonna like this premise as well, maybe not the question, but what if we affirmed with one word, and then the next day the district court said to you, I'll give you a stay of the 1997 regulation without briefing if you want it. What would you say then?
Oh, well, I mean, sure, we would take that too, but I think that would probably be beyond.
I'm not saying these are realistic, but I'm asking because I think you would take the stay. Why would you take the stay?
To again whack the 4th mole, I guess as it were.
Yeah, and so now you're not going to like this as much, but I think that shows that you need to stay the 1997 regulation in order to redress the injury that this stay is supposed to redress.
Well, I think this gets into probably like the reason why we're having issues with this is because we don't know. And I think there were various questions about this to the government, sort of at what level, is there a delta, right? Has there been a change in how often expedited removal is being applied to parolees? And we're not in a position to assess that. And certainly if there are questions about that, I suppose that this court could remand to send the case back down to the district court and let the parties hash that out there. And maybe that is the best avenue to get these questions answered, because we don't have the information that the federal court does. For our motion for summary judgment, we certainly do have declarations from private practitioners who are representing individuals who've been placed in expedited removal, who say my client has been placed into expedited removal following all of the litigation around the district court's stay and this court's denial of the stay pending appeal, and yet, just notwithstanding the district court stay of the challenged agency actions, my person is being put into expedited removal, and that's the record. That's all we have access to, right?
Which is why you would want the stay of the 1997 regulation.
And what we have shown,
yeah. Which is also why it may be the case that the stay on appeal. But it's not addressing your injury. But I think you've answered my question.
Well, I just want to point out, I think that it's a little bit tough because I wonder if we had moved on all 4, again, when it seemed pretty clear that the government was not relying on the regulation last summer, I mean, would we have an issue of being able to point to which of the 3 different challenged agency directives or the regulation was ultimately responsible for a particular person being put in expedited removal?
That the day you filed this stay, the government was injuring you with the 1997 regulation.
Yes, yes, as a technical matter, yes. But
I mean, I guess your position, I assume your position is that if in the world that includes the directives, there's a mandate to use expedited removals. So there's 100% likelihood that expedited removal will be visited on your clients. But in a world without it, that exists with the regulation, there's still a possibility, but it's 1% because the government decides it's going to expend its resources elsewhere in the absence of or at least immigration officers decide they're going to expend their resources elsewhere in the absence of the directives. Then yes, there's still the possibility. Yes, it still causes injury, but it's the bulk of the concern has to do with 100% likelihood as opposed to the 1% likelihood, which you might have thought was zero. But actually your complaint indicates that you at least think that there's some possibility under the regulation, but that delta would be enough. Whether that's true, whether as long as it's discretionary, the delta could make a difference, I think is a question of law, but I take it your position is that, we would be dealing with the big enchilada, and then we would still like to deal with what's left too. But for purposes of redressibility and irreparable injury, it still gives us something meaningful to take out the certainty, even if there's still a remote possibility. And I'm obviously loading into it what the delta might or might not be. It may be nothing, but it may be something.
yes, that's correct. And I think that the record before the district court shows that there was a delta, and at the very least, that the district court didn't err or abuse its discretion in finding that there was a delta to support a finding of redressibility.
It may not be abuse of discretion, but it might be legally insufficient for redressibility, which would be a per se abuse of discretion.
I think that it's redressibility, especially in this circumstance. It is a question of fact, but also a question of law, but also a question of fact. And the facts before the court at that time, first of all, are not what they are here before this court. And also the point is that the facts before the district court at that time supported the district court's conclusion.
I think you at least have to accept this proposition, though. If, as a matter of law, the rule were that any possibility that the same consequence could befall your clients is enough to mean no redressibility, then you can't prevail because you acknowledge that there's at least some possibility under the regulation standing alone.
Yes, I think that's correct. But I think that
that may or may not be
any
as a matter of law,
possibility,
but that's that.
And you've offered even assuming the district court's findings are correct. I mean, there obviously has been a delta, even if we assumed it was attributable to the directives. You haven't provided a legal reason why a delta that's based on enforcement discretion would satisfy redressibility. And I know we've already gone around, but you keep going back to the facts, but you haven't provided anything as to a legal reason why that would constitute redressibility.
No, we can certainly look, and if we find anything, I'll say that in preparing for this argument, the factual record is just so stark that we yes. I can address the merits if you would like to, Your Honors. I don't know if you have questions about that.
Or questions about it? I have a question about the characterization of the merits, just so I understand it. So there's the two sources of authority that the government's bringing to bear here, the designation one and the arriving one.
Yes.
Is it right? Do you agree with the understanding that if, and you'll resist the premise, but if the government has authority under the arriving source, then as for purposes of this case, because the plaintiff's class consists of individuals who got parole at a port of entry, then the designation authority doesn't matter?
Well, I think that this is the legal oddity that the district court identified, which is that if you accept the government's interpretation of the statute, then people who came to the port of entry and who were inspected and paroled and followed all the rules are forever subject to parole because they are forever considered to be arriving. And then the language in the designation provision that exempts people from having been, first of all, the language that exempts people who have been paroled from being subject to a designation under the designation provision basically has no meaning. But then in addition to that, it means that people who enter the country unlawfully and who come here and are able to evade detection and apprehension for 2 years are then forever insulated from expedited removal. And that puts the two populations, that treats them very differently. And,
So, and the government's response to that, of course, is that yes, for purposes of expedited removal, there's that seeming discrepancy. And I agree with you that that seems anomalous, but then there's other consequences that attend coming here unlawfully and staying here that don't apply to someone who gets parole. And so there's just a question of whether that all washes out. Because I mean, I think with respect to whether the government's position is what you say it is, your complaint says it is, right? Because your complaint says that the overbroad definition of arriving alien in the regulation means that any paroled individual may be subject to expedited removal at any time, regardless of the fact that they were lawfully paroled. So I think it then collapses back into the question of whether this regulation is a valid interpretation of the statute, because if it is, then the regulation by its terms says, doesn't matter when, as long as you've been paroled in, you're subject to expedited removal.
yes, it does go back to that with respect to the arriving in provision.
Yeah.
It's also our position, of course, with the designation provision that if you have been paroled, you should not be subject to expedited removal pursuant to a designation made under the designation provision. But the point, the government certainly has taken the position that it's both and. Our position is neither.
And you have
nor.
to be right on that, right?
Yeah.
You have to be right on that it can't be either. Now, with respect to the designation one, then if the arriving doesn't work for the government, then you still have some benefit, because then anyone who's here for longer than 2 years isn't subject, even by the government's own argument, to the designation authority. So it doesn't sound like practically that would give you that much, but in terms of getting relief for you, it's not enough to win just under one or the other. You'd have to win under both, right?
We would like to win under both, and we think we should.
And you need to, because conversely, if the government can win, at least as the arriving one, if they can win as to the arriving one, then they don't need the designation one.
This is correct.
Unless the only scenario I could conceive of is along the lines of some of the questions that Judge Walker was asking, which is if there's somebody as to whom parole has been terminated and they're here for longer than 2 years, and you think that the arriving authority doesn't apply to someone whose parole has been terminated as opposed to someone who's still in parole, then it could be that there's relief available for that subpopulation.
Yes, but I would like to point out that this position that the government articulated today, that the arriving provision doesn't apply to someone whose parole has been terminated, I think is new. It is not.
Well, I thought they were taking the other opposite position. I thought they were taking I thought they were taking the position per the language of the regulation that even if parole has been terminated, the arriving authority continues to apply.
Yes, if that is their position, yes, that if it doesn't matter as long as you are if you are a parolee, essentially, it's the government. It's our understanding from the government's briefing that you are subject to the arriving in provision sort of indefinitely. That
Right.
Arriving. I mean, I don't know.
Not just indefinitely, but even if your parole's been terminated.
Yes, this is correct. And
I think that the plain terms of the regulation just say that. It says an arriving alien remains an arriving alien even if paroled and even after any such parole is terminated.
right. The point, the effect is I guess this gets a little bit to the merits and sort of what was Congress trying to effectuate with these statutes. But the point of the arriving in provision was that the Congress was trying to address people who were coming to the port of entry or coming to the United States without proper documentation. And it's our position that parolees shouldn't be encompassed in that population. I can go into our arguments as to why, but then the designation provision shows there would be no reason for Congress to try to exempt parolees from designations that the Secretary of Homeland Security could make if forever they were subject to expedited removal under the arriving in provision. Like the structure of the expedited removal authority and the two populations that it's trying to articulate that are subject to expedited removal just don't make sense if you accept the government's position here.
So the government's position, I take it, per the regulation, applies to a subclass of parolees. It's those who get parole at a port of entry.
Yes, I believe so. And that's what's at issue.
Who gets parole, right? Or am I wrong?
This is correct. But what is at issue in our cases is individuals who have been paroled at a port of entry, who've been inspected and paroled at a port of entry. Yes.
Then can I ask you one question arising from some of the questions that arose in the earlier colloquy with government counsel, which is we have to do the inquiry for ourselves, so it doesn't matter at the end of the day. But you haven't taken the position, as I recall, that because the government says it has independent authority to effect expedited removal under the regulation, regardless of the directives, that the government doesn't have standing to appeal.
Yeah, this is an interesting question. I mean, as you know, the parties didn't really brief this. I mean, we don't contest the appealability of this matter, but.
And we still have to do, it's a jurisdictional question, so we have to do the assessment ourselves. But I just wanted to make sure that I didn't miss something that you hadn't raised that.
No, we certainly didn't. We haven't contested the appealability of the district court's stay here.
My colleagues don't have additional questions.
Have you identified anyone who's a member who is no longer on parole and has been here for longer than 3 years? Longer than 2 years.
I don't think so. But I did want to address one thing that Your Honor mentioned, Judge Walker, about you said that sort of the case law and the precedent indicates that individuals who are paroled are forever on the threshold of entry. They're always they have not entered and they're always arriving. And I would submit we think that that's not correct. I mean, if you'd like me to address it, I think you seem to get my argument, but I didn't want to let that go without.
I noticed it in your briefing that you don't think that and I think the topic you're talking about is someone who is still on parole and has been for any amount of time. You don't think that is an arriving alien.
Right. They are not, they have completed their process of arriving. They are not arriving.
Was clear.
Okay.
I do have one last question on something that was flagged in the earlier colloquy, which is, and this, I think if it goes to a legal issue, it goes to arbitrary and capriciousness, but this is about this sentence in the middle column of the relevant page of the CHNV.
Yes.
Federal Register notice.
Yes, I know what you're talking about.
So there's this sentence that we were focused on, which is if DHS were to allow the parolee to remain for the full duration, DHS would be compelled to place a greater. And that does seem problematic. And I think the government counsel acknowledges that doesn't actually work at the end of the day.
Yes.
And was your arbitrary and capriciousness argument, did it go to that sentence or was it, I understood it to be mainly about the previous sentence that had to do with somebody being present for at least the 2 years?
I can go back and look at exactly what we argued in our briefing, but I think the point is that there is this inconsistency, this unexplained inconsistency, including in the language about the government being compelled, and there's no explanation for it. And I think that with Judge Walker's colloquy, yes, it's correct that reliance interests weren't considered, but even beyond that, the agency still has to engage in reasoned decision-making and explain the rationale for just making the decisions that it did. And that's not present here, well, in this document or any of the documents, for, again, the notion that there is no time limit to apply expedited removal to parolees, but then here, the government would be compelled to terminate individuals' grants of parole before the 2 years so that they can subject them to expedited removal. And there's no explanation for that. Everything that they're offering in their briefing, I would submit, is post-hoc justification. It's not present in the documents. If
they would have said for purposes of the designation authority, we'd be compelled, that would be fine. And
Yes, I suppose so, but that's not what the
I
document
didn't say that.
says.
I mean, it's just the question is whether that's what was the kind of background understanding, but it doesn't say that. And I think government counsel forthrightly acknowledged it doesn't say that.
Right.
But if they were only talking about the designation authority, then they could mean compelled as to the designation authority, as opposed to compelled writ large.
Yes, that is one way to harmonize what's going on here, but again, that's not in the document.
Okay. Let me make sure my colleagues don't have additional questions. Thank you, counsel.
Yeah.
Mr. Becker, we'll give you the 2 minutes you asked for rebuttal.
Thank you very much, Your Honor. Just a couple of things. First of all, I think that plaintiffs admitted that there's really nobody that they have identified who would have been subject to expedited removal, who wouldn't have been subject to expedited removal as a result of the stay than if there was no stay. And here, I also want to clarify the government's position on MMV and whether there would be review in this context. I think that under this, and the government believes under this court's precedent, that if there was the issue that Judge Walker was referring to, whether there was a plainly unconstitutional directive that was simply applying a plainly unconstitutional regulation, that in this context, Congress has made the decision that there just isn't judicial review available for that regulation. I think that the issue, like after the 60 days, I think the issue here is that an organization you would have thought might have challenged that regulation at the time. If that was the case, they would have had 60 days to do so. And even if you can assume that, I think there's other situations where a court creates a certain order and there's just no ability to challenge it later, and that applies the Constitution incorrectly.
So you're walking back your claim that there would be an ultra vires challenge possible, the application?
Yes, Your Honor. I think that under this court's precedent, MMV, I think that there's just not really an ability to challenge this in this context. You may disagree with that, but I do think that under this court's precedent, that is the availability to review things in this particular context among the immigration provisions that are cited in 1252 E3B is limited, and review of expedited removal generally is limited. Congress this court has recognized, going back to the original challenge to the expedited removal statute, that review is just very limited, and even if that review may be that lack of judicial review may be unfair. As to the district court proceedings, I think right now the plaintiffs said for months they were going to file a partial summary judgment motion. They recently did so a couple of weeks ago. We've moved to stay consideration of that at this time. Their motion focuses predominantly on the arriving alien regulation, although I think although seems to incorporate their prior briefing on the designation provision. So I'm not exactly sure what that proceeding is going to be about, but that's going to be that's what's going on in district court currently. I don't think I think the government has at least an extension through April 16th on any sort of briefing in that case.
I have one question for you before we call today for this argument. So the questions come up for redressibility and irreparable injury purposes. Suppose that there is 100% likelihood that expedited removal will be applied to a plaintiff if the directives are in place, but it's a 1% possibility if the regulation is all that there is, which is to say there's still the possibility. It's just quite limited, but there's a certainty with the directives in place. I did not understand you to be taking the position that if that were the state of affairs, and put aside whether it's the plaintiff's burden to show that's the state of affairs, whether there's evidence from which one could reach that conclusion. I'm just assuming all that away for now. I'm just asking the question as a legal proposition. If that were the state of play, I did not understand you to be taking the position, but correct me if I'm wrong, that in that situation, there's no redressibility and no irreparable injury because of the possibility. Now, that still could be the correct legal proposition, but I didn't understand you to be taking that position, but am I wrong?
Your Honor, if the regulation, On that particular position, I think that the government would say that the plaintiffs have presented no evidence that that's the case here, that it would be such a large discrepancy. And number two, I don't think that this court's case law really talks about the difference between that delta as mattering here. I mean, I think that's evident from the Doc Society case as well as some of those third-party cases where, but I think there is some loose language in those cases saying that, you know, it might matter if there was more evidence as to the direction was going to be
I'm just
less.
asking for the legal proposition, which is I understood your argument to be that the plaintiffs haven't shown that there would be a difference in the practical likelihood that expedited removal will be applied. But I might be wrong about what I understood your position to be. Is your position that it doesn't matter if there would actually be a practical difference, as long as there's a legal possibility that expedited removal could be applied based on the regulation alone, no matter how small that possibility is, that's enough to mean there's no redressibility and no irreparability?
Your Honor, I appreciate that. I think that our position is actually both. I think it is the second, that as a legal matter, on the redressibility context, if a plaintiff does not challenges a guidance document, it doesn't challenge underlying regulations, that there is simply no redressibility if they're doing the same thing.
Even if the plaintiffs showed undisputedly that there's 100% likelihood with the directives, there's a 1% likelihood with the regulation alone, and you don't contest that.
Yes, Your Honor, because I think this gets to the enforcement discretion issue. So in the documents here, as the designation provision, I think you have a document that's saying, you know, we should apply expedited removal pretty much all the time to these folks that qualify. And then in the February 18th email, the plaintiffs includes language that, you know, that expedited removal may be applied to arriving aliens. So I think that whether the government is going to exercise its discretion in any individual situation, which is I think what plaintiffs would have to show in one manner or the other, I think would not be shown by that.
So you think even if that evidentiary showing were made, the one that I hypothesized, as a matter of law, that still wouldn't be enough because there's some possibility that a particular person could be subject to the expedited removal per the regulation?
Yes, Your Honor. And I think in an associational standing challenge, it would be very difficult to assume that to find, you know, one member and whether the government, an entirely separate actor, would actually decide to exercise their enforcement discretion one way or the other. And to be able to predict that as a court, I think that would be an entirely speculative exercise.
Okay.
So if imagine that it's not this case, it's a case where a court can issue an injunction and the government is arresting 100 people a day and has been for months. And a court issues an injunction that enjoins every law enforcement officer except one. So the chance that the government continues to arrest someone is still like 1%, but people who would be arrested if all law enforcement officers were not enjoined.
Your Honor, I think
is your position the government wouldn't suffer an injury? Like, let's say on the winter factors, there would not be irreparable injury to the government there?
Your Honor, I think there would be irreparable injury to the government there. And the thing I think that this argument is a little difficult on is that there's the factual issue that there would just be less enforcement officers or less ability to do it. And then there's a legal issue, whether there is these legal documents or like regulations that allow the government to exercise its enforcement discretion to do something or the other. And I think that on the case of if all officers besides one were enjoined from acting, then in that case, that seems like a factual issue that would suggest the government had irreparable harm because they just would functionally not be able to arrest as many people.
Okay, I'll think about whether, sorry.
Oh, go ahead. Yeah,
I was going to change topics.
Go.
Imagine in 1997, the government promulgates a regulation that says expedited removal can be applied to people who have been here for 3 years. We're not talking about parolees, okay? Just take them out of the picture. People who've been here for 3 years. That would be an illegal regulation, right? Will you assume with me that?
They expedited removal to people who were here for longer than 3 years.
the statute says 2 years, so I'm giving you.
Oh, under the
regulation that says-
designation,
that says
under the
3 years.
designation provision, if the arriving alien provision didn't apply, yes, that would be.
Yes, yeah, no, we're only doing designation provision. But that, for whatever reason, no one challenges that for 60 days. I agree with the government. I think no one can then go to court and seek vacatur of that regulation, like stark as that consequence would be. I agree with you. Here's where we disagree, and we'll give you one more chance to tell me why I'm wrong. Imagine in 2025, the government promulgates a new regulation, and it says, we are going to increase expedited removal enforcement actions for people who have been here for 2.5 years. We have the authority to do it because of that 1997 regulation. And then a plaintiff files within 60 days and seeks vacatur of that 2025 regulation. It says this regulation is not authorized by statute, so the court should vacate it. And the government says, oh, well, it's authorized by the 1997 regulation. That would be a losing argument, right?
Your Honor, I think if we're talking about two regulations, I mean, a new regulation, the new regulation may have reopened under this court's reopener doctrine. It may have reopened the old proceeding. So that would be a different
say that, because then your March 25th CHNV notice might have reopened their ability to challenge the 1997 regulation that actually does exist, not in a hypothetical scenario.
Well, Your Honor, the reason that I was saying that was you were referring to 3 years versus 2.5. I mean, if you change if you're actually changing the regulation, that's a little bit different.
Okay, well, let's say 3 years.
I mean, in that case, it's applying the 1997 regulation.
You think the government could promulgate a regulation in 2025 that the statute does not authorize, and that no one could get it vacated within the 60-day limit?
Your Honor, here the government was simply applying its enforcement discretion.
In my hypothetical.
I mean, in your hypothetical, a new regulation would be challengeable within the 60-day limit.
And if that new regulation conflicted with statute, it would have to be vacated, correct?
Yes, that's correct. But the question would be the question would be, the difference there would be because there actually is a new regulation. So that's challengeable within 60 days.
All right. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honors.
Why don't we take a short recess and come back in session?
Stand, please. This honorable court, take a brief recess.
I saw friends.
Stand, please. This honorable court is back in session. Please be seated. Okay. Case number 25-5333, Appalachian Voices et al., Appellants, Institute for Sustainable Communities versus Environmental Protection Agency, and Lee M. Zeldin in his official capacity as Administrator of the United States Environmental Protection Agency. Mr. Grillo for the appellants and Mr. Bailey for the appellants.
Good morning, council. I think it's still morning, barely. Mr. Grillo, please proceed when you're ready.
Good morning, Your Honor. Just barely. May it please the court, my name is Benjamin Grillo, and I'm representing the appellants in this matter. I'd like to reserve 2 minutes for rebuttal. Thank you. This case squarely challenges the elimination of an entire congressionally mandated grant program for policy reasons. Plaintiffs properly pled both APA and constitutional claims in the district court, challenging that elimination. And this court should reverse the district court's decision to dismiss the claims and remand for further proceedings. Now, this court has recently been presented with similar issues, and we recognize that the outcome of this case may, to some extent, be guided by this court's forthcoming en banc decisions in Climate United and in TEU. However, this case is distinct. First, Congress created a mandatory grant program. It said EPA shall award $3 billion in grants. Second, plaintiffs pled facts demonstrating that the executive decided to eliminate the entire program on the program level. And third, the statutory command remains in effect. The statute has not been repealed. And further, unlike other cases which have come up on preliminary relief, this case is here on a motion to dismiss. And plaintiffs have pled plausible APA and constitutional claims, and they should be heard in the district court. First, this case is not moot. The statutory language here in HR 1, which defendants point to, is clear. It rescinded only unobligated balances. Now, unobligated balances is a term of art in fiscal law, and it is designed to provide certainty to the government. The OMB circular that the government cited in their brief, a few pages later describes in detail just why unobligated balances are limited to certain terms.
So can you just address specifically why do the termination letters standing alone, in your view, make these funds, I guess, not unobligated? Or why is the termination letter not sufficient to unobligate the funds?
Certainly, the termination letters themselves, if you look at the language of the letter, not only does it identify that it provides notice, which is the first step of a termination process. So the termination letter initiates a termination process, and EPA's regulations set out as part of that process two important things. First, an appeal. So the notification in the letter includes the opportunity for the grantee to notify EPA that they disagree with the termination decision and to have an appeal. That in itself does not create some uncertainty about whether those funds are in fact obligated or de-obligated. So that alone creates sufficient reason for why these funds were not unobligated. And the second reason is that, as EPA explained, there's a final financial report that needs to be submitted. And that report is an accounting by which the grantee then identifies what's outstanding. EPA goes back and forth with them. And only once that amount is set, do the funds become unobligated. And that's...
Do you have any precedent for suggesting, so the government has conceded that costs that were incurred before termination and any closeout costs will be paid to the grantees. And everything beyond that, although it may not be fully determined or fleshed out, is no longer obligated. So the amount hasn't been set through, the various processes. But does that, I don't know why that would necessarily mean that those funds continue to be obligated.
So, Your Honor, if you look at the OMB circular that the government cites, A11, and you go to page 27, in the context of a maximum price contract, it makes the assertion that as a general rule, the amount of obligation is the maximum liability to the federal government. That's what's set at the time of obligation. So let's say you have a maximum price contract, and perhaps there's a downward adjustment. Perhaps the vendor is able to provide it at a lower cost, and that maximum price contract needs to be adjusted. Only once that downward adjustment is written down and there is, quote, documentary evidence that the price is reduced, only at that point does the delta become deobligated. So there needs to be some certainty, because otherwise you could run into an Anti-Deficiency Act problem relatively quickly. If you considered everything deobligated and the actual amount that was owed was more than that, you've created a liability without an obligation. So the way that the financial system works is to keep funds obligated until they become
I think that makes sense as a general matter, but with respect to the Anti-Deficiency Act. But here, Congress has specifically rescinded. And so we also have to give meaning to what happened in the OBBBA.
So what H.R. 1 did and what Congress did is they rescinded unobligated balances. And this background understanding of fiscal law certainly was present. And it's understood that when asked, the chair of the Environment Committee, Representative Griffiths, stated in response to a question about what does this do to the grants that EPA has started the termination process on. So in response to that question, he answered, as of right now, that money is not available to us because it has been obligated. And he recognized, and we do not dispute, that a future act of Congress.
One member of Congress.
Sure, the chair of the Environment Committee, who was leading the effort to rescind these funds, said that. But it's not just his word. It's the fact that the EPA director of the Office of the Controller, in an email that's cited in our briefing, was asked by an internal employee, are we deobligating these? And she responded, we do not process deobligation until the final financial report is completed. This matches EPA's regulations. It matches this background understanding of financial law. It matches
Which is after the closeout process, right?
After the closeout process and after the appeal process. Those two work together. And as counsel for EPA stated in the en banc argument a few weeks ago, the funds are not technically deobligated until the closeout process is completed. And technicalities matter here. And this is a matter of how this accounting worked. And so what Congress did, as reflected in the CBO score in July of 2025, was rescinded the balances that were unobligated on that day, which was $516 million, not the entirety of the entire grant program. And the rest of those funds remain. And importantly, Congress did not repeal the statute. So that statutory obligation remains, and EPA is still required to comply with the effectuation of the program.
Can I ask if, so suppose that we accept your submission on mootness so that the dispute is not moot. Just assume for purposes of this question that we get past mootness. Then is there, and you can't obviously know what's going to happen in NTEU and Climate United, but do you have a reason that no matter what happens in those cases, we should still reach a conclusion in this case? Or the natural course would be that those cases have, you acknowledge, and I think everybody acknowledges, some overlap. And the natural course would be to see what happens in those cases when those opinions are issued, and then reach a conclusion as to how that affects this case.
I see two paths there, Your Honor. I think it may make sense as a matter of judicial economy to wait on this case until those are decided and then rule. I also think that it would be appropriate to send it to the district court because we have stated a claim under a motion to dismiss standard, and then allow the district court to apply whatever decision is reached in NTEU and Climate United. But in either case, we have sufficiently met the pleading standard. And I think taking inferences, accepting our facts as pled, we have stated a claim for the elimination of this entire grant program.
So even if it went back to the district court wouldn't do anything until the on-bank decisions were issued. Is that the scenario you're hypothesizing, or are you hypothesizing something different?
So for the APA claims, I believe that the district court could rule now, regardless of what happens in NTU and Climate United, because of the distinctions and the ways that our case is different. The district court reached its constitutional conclusions in large part relying upon the Dalton analysis that's squarely presented in NTU and Climate United. So I would agree that the district court would not be prudent for it to rule on that at that point.
And then can I ask you about the timeline and the appropriation? So the appropriation law says that the funds remain available until September 30th, 2026.
Yes, Your Honor.
So that's coming up later this year.
Yes, Your Honor.
And so the question becomes, what effect does that date have on the future litigation of this case, if in fact it continues?
So that's a question for the defendants, Your Honor. That's a question for the government as to how they intend to carry out their mandate here to effectuate.
But what's your view about that? I mean, you're a party that's directly affected by whatever the effect of that date would be.
So EPA would be required to, in our view, obligate the funds by September 30, 2026. Whether they obligate them to our specific plaintiffs, whether they recompete for them in some new process, perhaps an expedited process, that is a question that needs to be squarely presented to the defendants. And our requirement would be that they, in fact, effectuate the program. But I don't want to prejudge the outcome of what that would look like or what we would agree to.
So what was supposed, for example, that this case remains in suspended animation past September 30th, 2026, just where it is right now.
Yes, Your Honor.
Just suppose that happens. Then what, in your view, what's the effect of the September 30th date having?
There's certainly case law in this circuit that under Costle and other doctrines that as long as our case was filed before the lapse in appropriations deadline, that the litigation can continue and the court has inherent equitable power as to whether and how to proceed in that context. We're not there right now, but in our view, if this proceeded past that date, that's certainly an argument we would make.
That's the line of cases that you'd be drawing on.
Yes, Your Honor.
If the district court reached the merits of your constitutional claim before addressing standing or mootness, would it make sense under Steel Co. to send it back to the district court for the district court to address that first?
If this court has questions about standing and mootness as a factual matter, then it's appropriate for the district court to evaluate those. We have strong arguments, as the complaint read, in our favor, accepting it is true that we have established both standing and mootness. That is not moot, but that outcome is understood.
Okay.
So the grantees press their claims under 706(2), right? That the so-called shutdown is contrary to law. But I'm wondering whether we should think about the claims more like 706(1) claims for, or am I mixing that up? Well,
I think you have it right. You have it right, Your Honor.
Okay, sorry. For agency action unlawfully withheld.
Right. So
The withheld action is grantees want EPA to continue to provide this grant program.
what EPA has done, and what the heart of our 706(2) argument is that they have decided that they are not going to effectuate a grant program. So they made a directive, and it was a decision that they were, for policy reasons, going to eliminate the entire program. And so as an initial matter, what that looked like was the termination of the individual grants, but has also resulted in the failure to award new grants. They make no effort to suggest to this court that they intend to do that.
So why is that not 706(1)? Right.
So
Seeking to compel EPA to run a grant program that you say Congress requires, that's legally required.
they say our position is that they took an action, and under 706(2), we can vacate and set aside that action. It was unlawful for them to take this action. And then as a result, the statutory mandate of 138 is incumbent upon them. And if at that point they fail to follow the law, then that's a 706(1). But we brought a 706(2) because they took a discrete action here.
Where's the discrete action, right? So in NIH, the Supreme Court stay opinion in NIH, there was a separate guidance document, that set out a policy. Here, there is a series of actions to terminate grants.
So here there's an underlying discrete policy decision that was made in February of 2025 that was delivered verbally by Deputy Administrator Voiles to his subordinate Daniel Coogan. And it was memorialized in email and said, I want you to eliminate these programs that I have identified by assistance number listing. Assistance number listing is the EPA database for the entire program. This is not talking about individual grants. It's an elimination of an entire program going forward. And then that chain of events was attested to in a declaration that was produced in federal court in response to a judge's question saying, what happened? And so that action sufficiently meets the hallmarks of Bennett versus Spear. And certainly reading the facts in the complaint in our favor, we have certainly pled a final agency action for the purposes of a motion to dismiss.
Okay, make sure my colleagues don't have additional questions at this point. We'll give you a little time for rebuttal. Yep. Mr. Bailey.
Good morning, Your Honors. John Bailey for the United States. May it please the court. This court can affirm on either of two threshold grounds. First, this case is moot. After EPA terminated these grant agreements, Congress expressly rescinded the unobligated funds appropriated for environmental and climate justice block grants. Upon termination, the only remaining legal obligations were for allowable pre-termination and closeout costs, which EPA has already agreed to reimburse. The balance of plaintiffs' awards, along with any other uncommitted funds that might be used to prospectively fund the various programs, were pulled back by Congress in the One Big Beautiful Bill Act.
Mr. Bailey, what is your best evidence for the fact that a termination letter standing alone makes these deobligates the grant funds?
Sure, Your Honor. I think
because the government hasn't offered any other evidence of what's happened with these funds in terms of moving towards deobligation.
you're correct. Our position is that it is the fact of termination, the action of termination, that in this context makes the funds an unobligated balance in the sense of
Why is
HR1.
that? What is your support for that? I mean, we're not budget law experts, and there's very limited briefing that the government has offered to support this position.
Understood, Your Honor. And we tried to find the best authoritative textual sources. And for that, we point to the OMB circular, which defines an obligation as a legally binding agreement that will result in outlays immediately or in the future. And so we think of these agreements, those are the binding obligations that give rise to the obligation in the first instance. And so upon termination, when that legally binding agreement is no longer operative, at that point, the funds become unobligated within the meaning of HR1.
What about the fact that those unobligated funds, so the grants are terminated and the government thinks so the funds are unobligated, but agrees that costs that were incurred before termination and any closeout costs remain obligated.
Correct, Your Honor.
And so there's some uncertain amount of unobligated funds. I mean, because it hasn't been set. Does that matter for the purposes of budget authority?
I don't think it does, Your Honor. I think that's right, that at the moment of termination, because we haven't necessarily completed the reconciliation and closeout process, that the exact quantum of funds that remains obligated under the OMB regulations, it is indeterminate. But I don't think that means that Congress isn't able to rescind those funds. It used very specific language, unobligated balances. And I think part of...
Yeah, I think there's no doubt that they can rescind, but the question becomes, when do they become unobligated?
Yeah.
Do they become unobligated at the moment? I take it you don't think there's any difference between unobligated and deobligated. It sounds to me like I think there is a difference.
Unfortunately, Your Honor, I think that the term...
I don't know if it's unfortunate or fortunate, but I'm curious as to what your position is.
I think that deobligated is unhelpful because that's not a term that I understand to be defined in any regulations, regulatory materials. I think that's kind of a colloquial, like agency speak for what happens at the end of reconciliation and closeout.
Right.
Well, before I encountered this case, I heard of the term deobligated, but I think we need to drill down on it. unobligated balance, the exact language in HR1. And I think the best way to understand that is by looking to what obligation means. So not to
So you think
complicate things.
there's at least a colloquial understanding of what deobligated is. At least I mean, that word is used, it's bandied about. And you think that the unobligated for statutory purposes predates deobligation?
Well, I think unobligated for purposes of HR1 looks at whether we have a legally binding agreement that's operative at the time of rescission. And so unless a court has, as maybe it may have been the case in some other cases before this court, unless a court has set aside that termination, vacated it, enjoined it, something like that, the state of the world at the time of termination, the agency took an action. It has effects, practical and legal ones, until that's disturbed by, as I said, a court order or something, enjoining it, vacating it, setting aside, which we didn't have here.
I think the question is whether that legal effect amounts to an either a deobligation or an unobligation. And to the extent you think there's a difference, and you appear to think there is, then whether that amounts to an unobligation, the termination alone, even though they're still working out yet to be done.
Sure. And I think that we concede that it's at least here factually indeterminate until at the end of closeout, those final financial reports need to be submitted. But I think as a functional matter, in addition to the textual reasons I just gave, I don't think it makes sense to say that, oh, well, Congress was only trying to rescind funds that were, the reconciliation was completed and fast enough or in a certain amount of time. I don't know why that should matter. I think the question is whether the agency viewed these funds as still committed. And Congress said, well, if the agency has viewed these funds as committed to someone, we're not going to pull them back. We don't want to disturb what the agency's doing. But when the agency has uncommitted the funds, which our position is that termination uncommits them in the relevant sense, well, at that point, Congress said, we're going to pull back funds that are uncommitted. And that was what the rescission was in HR1.
Mr. Bailey, can you point to any either court case or executive branch practice or regulation that suggests that the technical term unobligated balances could be an indeterminate amount, right? Because usually when you talk about balances, that's a kind of accounting term of art, suggests maybe that something like a balance has been determined, specific amount of the balance. So I'm just wondering if there's anything you can point to that suggests you could have an unobligated balance in that technical sense that is not yet settled.
I'm afraid I probably don't have a particularly satisfying answer for you, Judge Rao, but I do think that
part of executive branch practice that unobligated balances may sometimes not be determinate. I don't know.
Well, I think this is related to the interplay between the Recording Act and the Anti-Deficiency Act, where agencies, as a matter of practice, are going to have sums over-recorded on their books while this reconciliation or closeout process plays out. Mm-hmm. And so for that reason, you might not look at a pot of money as deobligated until the end of the process. But at least as a legal matter, those funds are uncommitted to, as far as the agency is concerned. They just are trying to figure out the exact quantum that they need to.
And so the rescission that Congress enacted of unobligated balances would apply to that indeterminate amount.
Yes, Your Honor. I believe that, as I said,
but you can't point to any either executive branch regulation or case that suggests that understanding.
No, and I don't believe that my colleague on the other side is pointed to one that said that would foreclose this reading. It's a tough textual question, but I mean, we have to ultimately, the courts will have to answer what was Congress doing here and what exactly were they pulling back. And I don't think we can say, oh, well, it really wasn't doing anything because, it just wasn't clear who the money belonged to. I think Congress was really looking at were these funds committed to, has the agency committed these funds? And if so, we're not going to disturb that. But for the pot of money that is uncommitted, is unobligated, we're going to pull that back. And I think that doesn't turn necessarily on whether that quantum whether the 120 days has passed that would allow the final financial report to calculate that exact sum.
And that's just a question along the same line. So the grant agreements themselves talk about reobligation where there's been a deobligation.
Yes.
And so is the way you understand the world that the language says deobligate uncommitted funds and reobligate them by an award to another grantee. And so the way you would understand the way these terms all get juxtaposed is that even though the reobligation happens after the de-obligation of uncommitted funds, which requires the process that would unfold to identify the amount that would then be re-obligated, that an unobligation has already occurred before any of that happens.
I would say that an unobligation occurs upon termination, and then I would say there's a closeout that allows the full or the determinate amount to be de-obligated, as the agencies say. At that point, now the agencies know, okay, we're not going to violate the Anti-Deficiency Act if we go ahead and re-obligate to a new grantee. So I see it as unobligation at point of termination. We go through closeout, and now agencies say we have de-obligation. Now we have an identifiable amount to re-obligate.
I see.
Yes.
Unobligation, then de-obligation, then re-obligation is the way you would.
Yes, Your Honor.
You would reconcile these various terms that are in the statute and in the grant instruments.
Yes, and to my understanding, I don't think the de-obligation is a word that appears in other regulatory materials or statutory materials. That's why I think it's most helpful to hone in on obligation in the OMB regulations.
It's in the grants, but I understand your point about the regulations in the statute.
Yes, Your Honor.
I think you may have just said this, but in normal situations, when an agency terminates the contract, the agency is not able to instantly re-obligate some of those funds.
I don't know. I think as a practical matter, I think, yes, as a practical matter, they're not able to immediately re-obligate from that same pot of money because they don't yet know how much of that pot of money has to go to the initial grantee for, allowable pre-termination and closeout costs. So as a practical matter, you need to allow the closeout process to play out. And then so I understand that de-obligation term to be like, well, now as a practical matter, we can go out and re-obligate. But at least for purposes of HR 1, I think the unobligated versus obligated is going to come down to whether you have that legally binding agreement in effect.
And then can I ask a question about, unless there's further questions along these lines, on the timing question raised with counsel on the other side. So what is the government's view about the effect of the September 30th, 2026 date on the litigation? And I'll just give you one scenario to hypothesize. I don't know, can't know what the scenario is going to be, but suppose this case stays in its current status as of September 30th, 2026. At that time, what is the government's position on what happens to this case?
Well, unfortunately, I think that does turn on whether a court agrees with EPA's understanding of unobligated balance, because EPA's position right now is that there is just no money left to fund, no money left that it may obligate to new grantees to which to run the program. Understanding that other amounts are over-recorded for reasons we just talked about, closeout is still playing out. But EPA's position is that there is no more funds that could be re-obligated to new grantees or to new projects. So if EPA's position is right, we would say that deadline is a nullity because either before or after it, there's no money left to draw from. I think that
does that, and then I'm curious, of course, as to your thought if that argument's doesn't carry the day. But before we go there, does that argument just collapse into the mootness argument? In other words, or is there a delta? So does that acceptance of that argument would necessarily mean the case is moot anyway? Or is there something else coming?
I mean, I think there could be a distinction, Your Honor, and one that I've thought of is even if we say that the balance of plaintiff's awards were not rescinded, and so there's some money left available to the agency until at least this deadline. As you may have seen, the statute reserves 7% of funds for administrative costs. EPA's position is that those funds have all been pulled back. And so it's unclear how the program would necessarily operate prospectively going forward, even if you believe that the balance of plaintiff's awards are still able to be obligated, so not necessarily mooting their one version of their claims. But yes, they are related.
Okay.
And I think to the second part of your question, assuming there is some quantum of funds that is left around as we approach the September 2026 deadline, I think at a certain point, we'd probably appreciate being able to submit supplemental briefs on exactly what the right remedy or effect would be. At this point, it's hard to know exactly what our position would be once that deadline rolls around.
Okay.
And
Make sure my colleagues don't have additional questions for you at this point.
if court has no further questions, I'll have to see my time, which I see I'm well out of. So thank you.
Thank you, counsel. Mr. Aguilera, we'll give you the 2 minutes you asked for rebuttal.
Thank you, Your Honor. At the outset, I want to point out that Congress can't rescind an unknown amount of money. So it had to be a finite fixed sum at the time of HR 1. And it's important to have this finality. Funds are obligated until they're not. So calling it deobligation, calling it unobligation, it can't be a Schrodinger's cat situation. Funds are either obligated or they're not. And for all the reasons that we've described, they were not unobligated balances at the time that HR 1 acted. And to read HR 1 in the way that the government is suggesting here would essentially be a repeal by implication, because what it would have done is have repealed all of Section 138. And that didn't happen. The statute remains on the books today. And
what is your best authority for the fact that an unobligated balance has to be determinate or specified? That it can't be in the process of being determined and then rescinded?
I think there's two, Your Honor. First is the OMB circular, which sets out that the amount of an obligation is the maximum liability and gives this example of a maximum price contract that then gets reduced. Secondly, even going to the letters, which is the only thing that the government points at for this assertion, there is, as recognized, an appeal process. And so in our view, the government has this process backwards. So the first thing that happens is a letter gets sent, and that notifies the recipient of the termination. And that's 200.341 notification. 342 is the opportunity to object and have a hearing and contest the grounds for terminating the award. And so in a world in which it's possible that the hearing officer would decide that the termination was in error, it would be inappropriate for the obligation or unobligation to have occurred already. And then after 342...
It just means that those funds wouldn't be an unobligated balance under the meaning of OBBBA.
Right. So this process was in play.
But that doesn't tell me why, when Congress uses the term unobligated balance, it has to be a determinate amount and not an amount that is like in process of being determined. So, so they want to say, things that are unobligated are rescinded. That's what the statute says.
Unless Congress acts the way the HR 1 works or a rescission bill works is that on the date that it passes, it looks at what's unobligated on that date. If it wanted to have a future effect, if it wanted to go to futurity, then it could have written something like that, but it didn't. It would have to use specific terminology. Like, for example, we're not going to allow raises going forward under this compensation statute. That would be a situation in which that would have future effect. This is a situation in which it is a snapshot in time of July 2025.
And your view is it can't be unobligated unless the amount has been specified and all the appeals have run out and the closeout process is finished.
And that comports with both longstanding EPA practice, EPA regulations, EPA statements of counsel at argument, the general background of the OMB circular, the Red Book, the nuances of fiscal law.
You don't dispute that the funds become uncommitted on termination?
I do dispute that, Your Honor, because there's first of all an appeal process. So it would not be appropriate for me to take my daughter's allowance unless I check with my wife first. And so there's an appeal process that works first. And then secondly, there's the closeout process about identifying the precise quantum. I do not dispute, however, that once the closeout process is finished and that accounting is done, that those remaining funds then become deobligated, unobligated, and become available to be awarded to some new grantee.
So I guess I was trying to introduce a different term of uncommitted because counsel was using that term and it's in the grant agreements also. And you think uncommitted is the same as deobligated?
For funds to be uncommitted, there needs to be some finality around it. And I think that what matters for this purpose is what Congress meant with unobligated balances. I'm also going to add in the fact that when HR 1 passed in July of 2025, there were still some grants that had not yet even been terminated, that didn't yet have a termination notice sent out for them. And certainly in that context, there's no question that HR 1 didn't affect them because they haven't even been notified. And what that does is it creates some redressibility because those grant funds were certainly untouched by HR 1. And as a result, some quantum of funds, regardless of the size, that gives us an opportunity to compete is enough.
Make sure my colleagues don't have additional questions. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable applicant is adjourned until tomorrow at 9:30.